Hello, everybody. Great to see you all. Yes, great to see you, Ava. Everybody missed you. I guarantee it. Yes, you are the star. We all know it. There's nobody more important than Ava. Yes, hi, baby girl. Oh my goodness. Are you happy? Are you happy Mama went live? Let me say hello to some people here. Hello, C-Rex, my beautiful friend. Hello, Nana Laura. Hello, Eileen E. Carlin. Oh my goodness. That's a terrible thing. Thank you so much, though. We've got time. Hello, Rocky Lennon. Hello, She's a Maker. I saw your heart on the YouTube post. Thank you. Hello, Chinny. Hi, Grandma Diggs. Hello, Shane. Oh my gosh, Ava. You are just having a time. Here, I know. The blue buffalo right here, her Santa snacks. She's waiting, not patiently. Can you blame her? Blue buffalo is her favorite thing in the whole wide world. Oh my gosh, I sealed these up good. I didn't want to take a risk, but the elves stole them. There, baby girl. Oh my goodness. Get a few more out here to have at the ready. Oh, so the case is exporting. Golly, I guess I did more than I thought I did today. Which, I don't think anybody's going to complain about that. More to watch. Hello, CE. Hi, sweetie. Oh my goodness. I would love if they would sponsor me. Honestly, dream goals. Seriously, dream goals. Sponsorship of Blue Buffalo and Lume. If y'all have not heard my infomercials for Lume, Lume is the absolute best body wash, body deodorant, soap. They are amazing. I cannot say enough good things about them. So if you struggle with body odor or even certain skin conditions, Lume can really help. Oh my gosh, I love you. You are so amazing. Your nose is really cold. My goodness. She was outside. Hello, Sir Philip. Give the budgies extra treats from me. Someday I want to see your aviary. I would love that. Billy would love to visit your aviary, but you would no longer have birdies in it if that happened. Oh, Bandit, you missed. Bandit, come here, baby. Ava, move. Ava, go lay down. Bandit, come here, baby. Come here, Bandit. I know, you're so focused on the dog. You're okay, baby girl. Come here. Come here, baby girl. Oh, you precious sweet thing. She is so perfect. She really is. I have never. Oh my gosh, she's perfect. I love her so much. She's so beautiful. Yes, yes, this is Bandit. Oh, look at that sweet face. She's got the most gorgeous eyes. I love her. I love her. Oh my gosh. And Billy loves her too. I'm so shocked on that. Yes. Yes, pretty kitty. She loves the window. Hello, Spider-Man. I love you. Absolutely perfect. Hello, Patrick B. Hello, Sherry B. Oh, my sweetheart. Well, you just make sure to hit that like button before you doze off to dreamland, but we'll be right here with you. You are so sweet. Thank you. I hope everybody has an amazing Thanksgiving. I will be here with you. For anyone who doesn't have somewhere to be. So I hope you guys are, out with family and friends and having the time of your life. But if not, you're welcome to join me. Hello, Jenny Green, sweetie. I think tomorrow, might do maybe just watch like body cam videos, some pet videos, just enjoy each other. And I'm not going to worry about, having content to make replay crew minis with or anything like that. Just watching videos. I think that would be a really good thing. I don't know yet. What you thinking? Oh, honey, that sounds great. I'm so happy to hear that. I'm definitely thinking that I should do it, more like evening time, but not night, like dinner time, of course. I don't know. Do people usually have Thanksgiving in the afternoons or in the evenings? Is it an afternoon thing? Maybe I should do like a lunch stream. Thank you so much, Patrick B. Do you have plans? Honey, you always are with me. It is an afternoon thing. Okay. I know some families do dinner, but I remembered I thought my parents always did afternoon, so I got confused. So maybe I'll come on day shift. I know they do. It's actually, they'll steal some of it fresh. A couple of them will. Billy won't touch it. If I get them canned turkey, like Sheba, 9 Lives, any brand, it doesn't matter. If it's got turkey in it, they won't touch it. They will not eat it at all. They are more seafood animals. Afternoon and then football. No, it's not my first Thanksgiving. It's just like I said, some families do it as a dinner thing because it's, such a big meal. But I remembered my parents always had us show up around 1. Yeah, I think, oh man, I'm going to have to compete with football. I don't know. My ratings will tank. My My whole, 35 people all go down to like 12. See, I'm not crazy. Thank you. Well, I might be crazy, but not on that part. You too, CE. Thank you so much. Oh, yeah. Kitty cats are sneaky. I've had some that really did. Yep, they would jump on top of the stove and try knocking the lid off of the big roaster pans, and yes. Oh, I know, honey. Do you think I take anything seriously? Ooh, nice. That's why we're together. Oh man, I would give anything to have a ham. Like one of those brown sugar cooked hams. Oh man, I love those. Cooked in the Nesco or something like that. Yeah, that'd be really good. I like turkey if it's done right. I don't like it when it's super, super dry. My parents could not cook a turkey without extracting every single droplet of liquid out of the meat. So it was always super dry, but honestly, it was still really good. Ooh, yes and yes. My mom made the best stuffing ever. So when she boiled the water for the stuffing, she would add in chopped celery and chopped onions into the boiling water and then make the stuffing as directed on the box. But when it was done, she would then add in golden raisins or dried cranberries and stir it in there, and then the moisture and the heat would kind of soften them some. Oh my gosh. Best ever. And it's so amazing with acorn squash. If you make that and then you take a half of an acorn squash and put it in the middle. Oh, I forgot. There's also sausage in it. Mild sausage cooked up. Yeah. And then so you've got your stuffing, your sausage, the dried cranberries or raisins. I preferred the raisins. And then you put that into the acorn squash half. Oh, best ever. Oh, it's so good. Yum, yum, yum. I remember back in the day when I used to help put cloves in the ham. I'd stick them in there all over it. Sometimes a couple too many because it was just so much fun. And I also did this Christmas ornament thing. You take an orange and you take cloves and you very, very tightly put the cloves. It takes forever poking the cloves into the orange. And it actually makes this potpourri ball that smells so beautiful. Hi, Chris Roche. Or is it Roche? Or is it Roach? I think have we done this? We've had this conversation before. And homemade mac and cheese, my daughter asks for that. I make, apparently, the best mac and cheese ever. Yvonne, hello, beautiful. How are you and my two Aussie kitties? I have never heard of Penny the Talking Cat. Yeah. There's a restaurant here called Max. It's not here. It's in the Dells. But my daughter, she frequently asks that. Roach, I am so sorry. Well, let me do this again. Hello, Chris Roach. I will try to remember that. Guess what just finished? Now I have to... How dare I? How dare I? I'm so sorry. Will you ever forgive me? Now I have to select the correct mouse first off. I have to come on. Why does it never... I click it and I wait, and then I have to click it again and I wait, and it just doesn't ever do what I tell it to do. But I always eject my hardware. That is something I am super, super, like, absolute about. Okay, now I'm moving the docket that I named Thanks Eve, and I am putting that onto my Sparky S2 drive. So if I forget what I named it when I'm going to stream it, y'all can remind me. Ooh, yeah, pumpkin pie is a staple around these parts. Auntie M, hello, my love. Thank you for joining us. I can be. Yeah, just ask Ava. Sometimes I even deny her treats. Yep, you got me there. Accidentally got 3 pies. There's no accidental about that. You sneaky little thing. I'm not the greatest fan of sweet potato. Like, I know it's really good for dogs. So if I get sweet potato, I'll cook it up for Ava. But as far as myself, it's not my favorite thing. All right. I have tonight's fun right here. Unfortunately, there's not a lot of that around here anymore. Especially Kendra's off to college. So it's just me and the pets. So there's a lot of, Jimmy Dean microwave griddle cake sandwiches. Or breakfast bowls. I'm a sausage, egg, and cheese or bacon, egg, and cheese kind of person. I'll eat that day and night, you name it. It goes very well with coffee. Kumara chips. Nifty. Well, we've had sweet potato fries at fast food joints, and they were like topped with cinnamon and sugar, and I'm not big on cinnamon, so I didn't really care for them. Fries and sweet just aren't my thing. I bet Ava would love it. They sure do, Patrick B. They sure do. And tuna. Don't forget the tuna. Now, savory I could probably get into, but people try to make them sweet here. Just because they say sweet potatoes doesn't mean that you have to add more sugar to them. You put a little bit of brown sugar on acorn squash with the butter, of course. Kangaroo biscuits. I've never had them. Shocker. Oh, yes, we had a whole conversation of gravy earlier today. C-Rex and I. Yep. She even sent me a picture to show me the extra gravy. And yeah, Auntie M, doesn't that sound familiar? We know who else loves gravy. Oh, sorry, I got a Billy butt in my way. Yes, 100% agree with that, especially garlic bread. Oh, yes, garlic bread with salt and garlic and butter. That is it. And you can use so many different kinds of bread for it. Oh, Hawaiian rolls, if you cut them in half and do the butter and garlic thing, just like I just said, you just, load them up with butter and then sprinkle powdered garlic on them and some salt and bake it at 375 for like 12 minutes. Oh my goodness, so good. Right, Billy? You can't have garlic because it's toxic to cats. But you sure try to steal everything that I have. I think it's the butter that you're after. I'm from Wisconsin. Cheese is, just second nature to me. We're a constipated little state here, we are. Probably hand churned too. Yes, I love garlic bread. It's kind of my downfall in life. I don't know. It's definitely a Midwest thing, for sure. Oh, thank you, Patrick. They think so too. Just look at how handsome he is. And the fan crowd goes wild. Yeah, if I pick him up, he will. Let's see if he'll tell me no. Usually, if I do this, oh, he used the other paw. Dang it! I wanted him to show you guys how he pushes my paw down. We have green bean casserole in Georgia. I think so. I think Campbell's made it an everywhere thing because they used to put the recipe on their cans of cream of mushroom soup. So I think it became an everywhere thing because of the Campbell Soup Company. And in Virginia, extra gravy. I prefer butter and salt on my potatoes. I like gravy. Don't get me wrong. Nobody send the pitchforks and fire. But I like gravy on stuffing and butter on mashed potatoes. Oh, that's so sweet. Billy, no. What are you after? You want the coconut oil? Should we do that? Yeah. We've got a butter and gravy war. Oh no. Oh no. We've got green bean casserole in Oregon. Hello, Linda Applegate, honey. We're talking about Thanksgiving foods. It's the topic for the night. Hi, you are so cute. I love you so much. Coconut oil is so good for their coats. Well, you do for the roux. That's how you make the roux. Oh, you want a little bite? It was on the back side. Every time she tries licking it off the spoon, she moves it from the front to the back and the back to the front. Ooh, that would give it a bit of an extra crunch. Do you want some more or are you done? Ava, you just wait. Yeah, the way to make that, the way I make homemade gravy, I was taught when I worked at a restaurant, and you boil, well, you could either boil like chicken stock, for instance, or turkey stock, whatever meat you've prepared, or if you don't have that, you use like bouillon. We used something called Better Than Beef, I think it was called, or no, Better Than Bouillon. And so we used that, and so water, and then Better Than Bouillon in either chicken or beef, whatever flavor we were making, and then boiled it, and then in a separate pan you melt down butter, and when you get that boiling a bit, you add flour to it until it's a thin paste. And then with the gravy water boiling, you take your whisk and you whisk in your roux that you've prepared in the other pan. Ew. But funny thing is that roux, yeah, that it works for cream soups as well. That's how you make cream soups. Sausage gravy is awesome. You don't need butter to make that. It's just like when you fry your sausage, you add your pepper, and then you just take flour on a fork and sprinkle it, and then the fat from the sausage and the flour make the roux as if you were using butter. So it's really good. Oh no, Earl cares about everything. It's Billy that doesn't give a flute. Well, that's what cooking is. That's why it's called a labor of love. I loved cooking. It was something that I really enjoyed doing. Now I can't stand long enough to be able to, so. Yeah. That's another way to do it. All right, guys. You want to start the party? Sherry B, you're so adorable. I love you. Oh, what's up, Earl? Ava. Quit that. She's trying to ride Earl like Earl's the pony. And my animals. I tell ya. Thank you, Patrick B. I'm so happy that you love them. They definitely make my life. This monster, too. Oh my goodness. I love her, though. She's so wonderful. Oh my goodness. Okay, so this first defendant is absolutely terrified. So terrified. Like you can see it in his face. He's like practically shaking. Judge.
Excellent. Stand in here. Put your back to the wall. On my back? Yeah. I'll say your full name to the judge. Hey, Gene Michael Dixon Butler.
Okay, sir. All right, Mr. Butler.
Yeah, sir. It was a full mistake. I was. Sorry, buddy. Oh, I'm sorry. I'm sorry.
All right. Is your address on Osborne?
Yes, sir.
Okay, and your phone number ends in 3130?
Yes, sir. 554-3130.
Okay. The state's alleging one violation of driving on a suspended, revoked, or canceled driver's license. That's a Class 1 misdemeanor. That carries a maximum fine of $2,500, 6 months in jail, and or 3 years of probation. That's the maximum, okay? The minimum is 0, so the court's discretion's from 0 up to those maximums.
Yes, sir.
Your options are to plead guilty, not guilty, or no contest. If you plead guilty or no contest, we can proceed forward into sentencing right now. If you plead not guilty, I'll schedule you for a pre-trial conference. You'll have to come back to court.
So you guys are taking me to jail right now?
No. I'll explain that to you here
I
in a
got my
moment.
kids right over there at the hotel.
Okay, sir, what you need to do is listen, and then I'll, if you have some questions at the end, then I'll address the questions.
After I get it.
All right, so just listen, and then I'll give you a chance to speak of questions, because most of your questions I probably will already answer when I go through this formal process, okay? If you plead not guilty, I'll schedule you for a pretrial conference. That's where you meet with the prosecutor, and one of 3 things happens. 1, the case goes to trial. 2, the case could enter a plea agreement, or 3, the case could be dismissed. You also have the right to an attorney. If you do exercise that right, you'll have to hire an attorney. The case does not qualify for a court-appointed attorney because there's no jail time being asked of this. So that probably answers one of your questions.
Yes, sir.
So you're not facing any jail time of a consequence to this charge. So it would be an imposed fine, most likely, and that would be it, okay? So now you can start breathing again and relax, all right?
Just worried about my kids out of this all costs.
Understood, all right. So, so you have the right to an attorney. If you wish to have one, you'll have to hire one. Do you understand that?
Yes, sir.
Do you wish?
I was driving.
Okay, so before we get to a plea, we're not there yet. Do you wish to have the presence of an attorney? Are you going to go hire an attorney?
No, sir, I'm not.
All right, I'm going to send you a letter that is waiving the presence of an attorney. You have to sign it saying that I explained that you had the right to an attorney, that you'd have to hire one, but you're waiving that presence, okay?
Yes, sir.
Now, before I take a plea from you, you have the right to personally appear in front of me, to have a personal appearance. I would like to do this by video here as the convenience, because you're here already on your arraignment and doing that, but I'd have to have you waive your personal appearance. Otherwise, pardon me?
What does it mean by that? Like I would have to stay in here longer?
No, just hold on a second. No, it doesn't mean. No, it just means they would walk you from where you're at now to across the street to stand in front of me.
Okay, now we can do that. Yes, sir.
Okay, so do you wish to waive your personal appearance?
Yes, sir.
All right, so the form that I'm going to send you is going to be the waiver of your personal appearance and also the waiver of an attorney, okay?
And that means I'll be going and seeing them over there. I'm trying to understand it, that's why I'm
All
sorry.
right, so let me explain it to you again.
I'm sorry.
So we're doing this video right now. This is by video. We're on camera. You have the right to be escorted in handcuffs over to the courthouse, which is across the street, and stand in front of me and give a plea. Or you can waive that personal appearance and we can proceed forward now by video and not have to march you through the streets and bring you over here.
Yes, that's fine.
Okay,
I'm sorry.
that's okay. So you wish to waive your personal appearance?
Yes, sir.
Do you understand what I'm explaining to you?
Yes,
Okay.
sir. I'm standing up. I didn't stand up first.
That's right. So the paper that I'm going to send you is waiving your personal appearance only and waiving the attorney, okay?
Okay.
All right. Regarding the plea, do you have any questions before I take a plea from you?
No, sir.
How do you wish to plea on the charge?
I'm guilty, boss.
All right. So we will move forward into the sentencing portion. I have to explain some rights that you're giving up by entering your guilty plea, okay?
The sentence.
Yeah, we're gonna go, after we waive, after I explain to you the rights that you're waiving, we'll go into sentencing. But as you know, I already told you that there's not jail time being asked of the case, so you're not facing jail time, okay? All right, first off, are you on probation or parole?
No, sir.
Okay. Okay, by pleading guilty, you're giving up the right to plead not guilty and require the state to prove your guilt beyond a reasonable doubt, okay?
Yes, sir.
You're also giving up the right to have a trial in front of a judge. You're giving up the right to have the assistance of an attorney at all stages of the proceeding, including an appeal.
Yes, sir.
You're giving up the right to confront witnesses against you and cross-examine them as to the truthfulness of their testimony.
Yes, sir.
You're giving up the right to present evidence in your own behalf and have the court subpoena witnesses in favor of your case free of charge to you.
Yes, sir.
You're giving up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt, and also giving up the right to a direct appeal. Do you understand that?
Yes, sir.
All right. All right. Rule 17.2 is read to every person that pleads guilty, is found guilty, or pleads no contest. If you are not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or removal, could prevent you from ever being able to get legal status in the United States, or prevent you from becoming a United States citizen. Do you understand that?
Yes, sir.
Understanding each of the rights that I've explained to you, you wish to give those rights up and enter your guilty plea?
Yes, sir.
Okay. You may file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. I'll send you a paper that explains what that is, okay?
Yes, sir.
It'll also explain to you how to set aside the judgment of conviction pursuant to Arizona Revised Statutes 13905 once all the terms of the sentence have been completed, and you may qualify for a certificate of second chance and may apply to seal the records pursuant to Arizona Revised Statutes 13911 once all the terms of the sentence and timeframes have been satisfied.
Yes, sir.
Let me explain to you the factual basis. That's the ticket that was issued to you.
I never received a ticket, boss.
Okay, I have the copy of it here. It's in your property.
Oh, okay.
Because you were taken into custody.
Boss, it's judge or your honor or sir, not boss.
Yes, sir. I'm sorry.
That's okay. All right. What it says here is that on November 25th of 2024 at about 9:24 p.m. you were contacted at or near 167 North Beeline Highway, that is milepost 253 on State Route 87. In that police contact, it was found that your driver's license was suspended, revoked, or canceled. You were operating a motor vehicle on public roadways. Also, it indicated that you had a civil traffic violation of having a suspended license plate for financial responsibility. That occurred in the jurisdiction of Gila County, which is in the jurisdiction of this court. Does that sound consistent?
Yes, sir. But I provided him with the previous insurance. I did do that. My girlfriend that I was with, she gave him the one that was on my phone. I know they took my plate, but later on she gave him the copy of my insurance for my phone because I had a lapse between August and the month after August. I switched insurance, so when my car that I'm getting from the bank, they told me like, oh, I need the new insurance. I gave them my new insurance. I thought it was all settled and everything, but I think there's just something going on with the system through Arizona because I have insurance and I have all that.
What happens is if there's a lapse in the coverage, they automatically send the suspension out.
That's what the officer was telling me. But when I got that note, I took everything back to the bank that I got the card from and everything, and they said they were going to take care of everything and everything was going to be settled.
All right.
I did have insurance. I do have insurance.
Okay. Well, so I'm going to take a plea of either responsible or not responsible on that violation. So give me a moment to explain it. So on those insurance policies, if you get like a 6-month policy and only pay month to month, if there's a lapse, then they automatically will send the notice to motor vehicle, your insurance.
That's exactly what I did is the 6 months.
And then they'll suspend it, and then when you get the insurance or renew it, you'll show good insurance or valid insurance, but it's still suspended, okay? So that's, may or may not have been what the case is here.
That's exactly what happened.
Okay.
That's exactly what happened, boss.
So at the time, the law enforcement contacted you, it showed that it was suspended for
That's
financial.
fine. I'll take it. It was.
Okay, so you want to enter a responsible plea on that?
Yes, I'm responsible for it, boss.
All right. All right, so regarding the charges, are you making your guilty plea voluntarily?
Yes, sir, I am.
Nobody forced, threatened, or harassed you to make that plea?
No.
Did anybody tell you would receive any lighter sentence or punishment if you pled guilty to the charge?
No, sir.
All right. The court will accept your plea, finds that you're making it knowingly, voluntarily, and intelligently, and will move forward into the sentencing portion now. Besides the information you've already provided me, do you wish to give more of a statement to the court?
Sir, I was traveling to go to Oklahoma because my adopted mom, she got terminal cancer. I wasn't supposed to be driving. My girlfriend has a driver's license. It's just we're coming down the mountains right there, and she was scared. So literally right when we came down the mountains, there was a cop right there. I got pulled over. It was my fault. I can't do anything about it. I did it, so.
Okay.
I'm just trying. I got my 2 kids right here at the Best Western across the street. I'm just trying to get back to them, make it, just make it. But.
Okay. Do you think it's possible you're going to get your license back?
To be honest, boss, I've never had one.
Okay.
I'm
getting...
a little slow with that type of stuff.
All right.
I'm still working on getting that part of my life situated and everything.
All right. So
I'm being honest, but yes, I would. They never offered me no driving classes or anything to go and try to, because with tests, it's a nervous thing, if I could get into a driving school.
Okay, so let me tell you
something like that, I could be able to do.
Let me tell you what I'm going to propose. Is the fine for the driving suspended violation is $441.
Yes,
if
sir.
you get your driver's license within 30 days of today's date, I'll reduce that down to $182.
Yes, sir.
So you would have to get a license and then show a copy of it to the court. That will give you the reduction in the fine.
Yes, sir.
The suspended registration is a mandatory minimum fine of $495.50, okay? You have an incarceration fee of $69 for the 1 day of jail that you've spent. That total comes out to a total of $1,005.50. If you get the reduction and you get a license, it drops it down to $746.50.
Oh, yes.
Regarding the $1,005.50, are you able to pay that today?
I'm not, boss. I'm not.
Okay, I can put you on a payment plan. How much can you afford to pay per month?
I could have. Let me do my math. I can afford about $150 a month.
Okay, so let's do this. I'll drop it down to $120,
Okay.
and then if you can pay more, you certainly can. But that way, it leaves a little bit of comfort room for
Yeah.
you.
There wouldn't be no way you could get me in the driving school anyway, because I don't know how to do it. If you could
What you need to do is find out why your license is suspended. Okay.
Okay.
So go to motor vehicle and ask them, why is my license suspended? And they'll tell you it's an unpaid ticket here or there or whatever the problem is. Then you'll have to go to that court to clear up that problem. Once that problem's cleared up, then you'll be able to reinstate your license. Okay, so that's really will save you a lot of money by doing that work as far as this court's concerned.
Okay.
So you may not have to go to a school or anything, but you may have to. I don't know. It depends why your license is suspended.
Yeah.
Okay. Have you ever received a DUI or anything like that? Okay, so it's not DUI related, so it sounds like it might be.
Really, I couldn't pass my test. I've never had a license, is what it was.
Right, well, and then at some point you got a ticket somewhere.
Yeah.
So, all right. So I'm going to put down here $120 per month. Are you able to make a payment today of $120?
I could probably, to be honest, my girlfriend has my phone and everything. I got about $700 on my card right now. I probably could make a payment right now, but it all depends on if it gets deposited later on today or in the morning, because I get paid on Wednesdays, but it's a holiday,
I'm just going to schedule you out 30 days, okay?
Oh.
So that way it gets past the holidays and everything else. So.
Okay, I appreciate you.
December 24th, so that's going to be close to, let's see here. Yeah, okay, so we'll make your first payment due December 24th.
Yes, sir.
That is not past the holidays, Your Honor, but it does give him some time at least.
All right, so what you'll be receiving from me is the attorney waiver form and in the video personal appearance waiver form. You'll be receiving a plea of guilty and no contest. You'll see my initials going down the column on the left-hand side. That's the rights that you waived by entering your guilty plea.
Yes, sir.
What you'll also be receiving is a judgment and sentencing form. At the bottom of that is the payment plan that you and I agreed to.
Yes, sir.
And further at the bottom, it tells you how you can make those payments. You always can send us a check or money order. That costs you a stamp. Or if you want to use the 1-800 number or the online, but there's a little bit of a merchant fee to those.
Yeah, yes, sir.
So keep that in mind. And then the warning of rights and notices that I talked to you about, how to set aside the judgment, seal the records.
Yes, sir.
You'll see an X at the top of the page. That's the domestic violence portion, does not apply to your case.
Yes,
I'm
sir.
releasing you on your own recognizance regarding the charges. Do you have any questions at all?
No, sir.
All right, so that you'll be receiving this paperwork to sign here shortly, and then we'll get you released.
Thank you.
All right, have a good day.
I did not see the Jim Carrey look until it was pointed out. But his mouth structure, his facial structure didn't help any in that respect. He looked a lot like him. I couldn't believe it. Once someone mentioned Dumb and Dumber, I was like, oh my gosh, how did I miss that? You're absolutely right. It was like twinsies.
Go right this way. Here, go ahead. Put your back to the wall. Stay holding to the judge.
My name is Tristan Matthew Meadows.
All right, sir, hang on one moment. I'll be right with you. All right, sir, do you still live on Saddle Lane?
Yes, sir.
And then does your phone number end in 1095?
Yes, it does.
Okay. The state's alleging 2 charges against you. Both of them are DUI related. The first one is a misdemeanor violation of DUI being impaired to the slightest degree. The second one is a misdemeanor also and having a blood or breath alcohol concentration at or above 0.08%. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a arraignment on the 11th of December at 9 o'clock in the morning.
Okay.
On that date, you'll need to be prepared to plead either guilty, not guilty, or no contest to those charges. Depending on how you plead will be what happens next with the court proceeding. The case does have mandatory jail time. You may have already served it. It's at a minimum of 8 hours. It also is jury eligible and has a mandatory minimum fine of $1,495.50 plus DUI counseling.
Okay.
The case also has the option for you to have a court-appointed attorney if you cannot afford to hire one. Would you like to have the court send you a financial statement to see if you qualify for a court-appointed attorney?
Absolutely.
Okay, so in that case, we could, you'll come to your next arraignment and plead not guilty, and we'll review your financial statement at that time to see if you qualify for the court-appointed attorney, but I'll get it to you ahead of time so you can complete it, okay?
Yes, sir.
Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately if you change address, do not leave the state of Arizona without permission of the court, do not possess or consume any alcohol or drugs without a valid prescription. You understand those release conditions?
Yes, sir.
Can you abide by those?
Yes, sir.
And you'll show up to court as ordered?
Yes, sir.
Okay, I'll release you on your own recognizance and get you a copy of this and the financial statement. So when you get released from jail, if you want to go ahead and do it right now and just drop it off at the court if you wish, or you can take it home and take some time, just bring it back with you on the next court date.
Yeah, absolutely. I'll get it for you.
Any questions?
Yes, so It has everything to do with the exact situation, but that day I'd been up until yesterday.
All right,
been up
yeah.
until about 4 a.m. drinking.
Okay, hang on one second, sir. So right now is not the time you want to give me details of the case, and I didn't mean to interrupt you, but I want to make sure that I'm protecting your rights. Right now, the only purpose of this hearing is to inform you of the charges, verify who you are on record, and collect a plea from you. So that will come later, where you'll get an opportunity to kind of give some details of the case. Okay. And if you're assigned an attorney, if you qualify, then you'll want to tell all those details to your attorney so they can talk to the prosecutor regarding that information, okay?
Okay.
I didn't mean to be rude, but it's really better for you not to discuss those details now.
Absolutely. I understand.
Okay? Anything else besides that, sir?
I don't believe so. You said I had to do a minimum of 8 hours of jail time, right?
That's only if you're found guilty or you plead guilty or no contest. So that's a sentencing portion. You may have already served it because
Okay.
you were taken into custody last night. So you could have already met the minimum qualification already. So that might be done, but it still qualifies you for an attorney because it was you have a potential of more jail time or a loss of your liberty. Does that make sense?
Right. Okay. So I will be released from the jail today?
I'm releasing you from custody today, correct, with your promise that you'll come back to court.
Yeah, absolutely. No
All
worries.
right, and then I'll give you a copy of the release order and your financial statement to complete.
Okay, sounds
All
good.
right, that'll be all. Have a good day.
Thank you, Your Honor.
You're welcome.
Stop right there, stop.
You just don't have to stop.
Yep. Sir. Got right in here. Are you back to the wall? You're gonna state your full name. State your full name for the
How are
tape.
you, Your Honor? Christopher Ray Rice.
All right, Mr. Rice, do you have a residence?
No, sir, not at this present time.
Okay.
I'm working, yes, sir.
How about an email?
No, I just now got a new cell phone, and I still got to get it activated and things like that.
Do you know what the number is to that cell phone?
No, sir, not yet.
Okay.
That's just not, yes, sir.
Once you learn the phone number, just make sure you let the court know what it is so we have a way to contact you, because if you don't have an email or an address, it's difficult for us to have a contact to you. So once you activate it and you get it turned on, call the courts, or I'll give you a paper that has our number on it, and just report it to us so we have a way to communicate with you.
Understood, sir.
The state is alleging one charge against you of disorderly conduct. That's a misdemeanor violation.
Yes,
You have
sir.
the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on December 6th at 1:30 p.m. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to that charge. And your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, make sure you report any address once you obtain one, if you obtain one.
Yes, sir.
Do not contact the alleged victim in any manner, which is Napa Auto Parts. Do not go to that location.
Understood, sir.
All right, and then, sir, what I'm going to do is I've ordered you to have level 1 treatment or be held in custody on a bond. So your options are to sit in jail until that next court date and post a bond to be released, or cooperate with Community Bridges for that mental evaluation.
Yes, sir.
and go to their program to receive some treatment.
I would love that. That sounds a lot better than having to sit in jail.
Okay, so they'll probably will be notified to come back to pick you up to take you to a facility. So you have to be willing and cooperate to do that, okay?
Yes, sir.
All right, so in that case, you'll be released to their custody, third party. Do you have any questions at all, Mr. Rice?
No, sir.
All right, that'll be all then.
All right, so right this way. All the else is on.
Mr. Davila?
And how are you doing today?
Now, I already time served you on your capias, so we don't really have to talk about that. But what we do have to talk about is the new charges you received when you got arrested on November 24th. And what you need to consider in deciding how you want to plead, of course, you have the right to hire an attorney. You have a right to plead not guilty because you have the right to set it for a trial. But the last consideration you need to make is that they are related to why the police officers interacted with you on the 24th. And for that reason, they are related to the higher charges that took you first to Potter County. Does
Yes,
that
ma'am.
make sense?
Yes, ma'am. So if I plead guilty on those charges, is there any way I'll be able to get out so I could go to my bonds and talk to my bonds on that?
No
Is it-
matter what you decide today, you're getting out today.
Okay, I'll
If
just,
you plead not guilty, you're getting personal bonds, which means it's a guarantee contractually that you make to the city of Amarillo not to miss the date and time on your bond.
yes, ma'am.
If you
It's-
plead guilty or no contest, your time served on everything except violation 2, which is no liability insurance. You still would owe a little bit on that. However,
Will I be
the
able
whole
to?
reason the police interacted with you is they pulled you over on these traffic tickets, then inside your car, there was more problems.
Can I tell you something?
Yes,
I felt it was an unlawful search, boss lady. Mom, I have no felonies for them to search my car. I had no smell. They asked to
then
search.
you might choose to plead not guilty if you feel like the stop was unlawful.
And I had no front plate, but the search was unlawful.
Okay, then do you want to plead not guilty and bond out and come see me on the date and time of your bond?
Oh yeah, I'll do that.
I'll tell you each of the charges. First is vehicle failed to properly display a license plate. Not guilty because you want to bond out, or guilty or no contest. How do you plead?
I want to bond, get out today, so I had to.
Well, no
play-
matter what, you're getting out today. So
Okay.
on your not guilty plea, you're gonna, as you're leaving the jail, you're signing a personal bond. It's
Is
gonna
that a
give
PR
you,
bond?
I'm sorry,
It's a PR bond, right?
yes,
And that's if I put not guilty, right?
right. You're getting
Yeah.
out today, even if you
If I
plead.
if I put guilty, I won't have to do no PR bond on that. I would just have to go to court on those.
But it could be used against you if you have a trial.
Okay, I'll just do not guilty on that, boss lady. I'll
Okay,
take-
the second charge, just so you know, is called no liability insurance. The second, if you had some insurance on that day, bring it so I can dismiss that charge. That's a PR bond. Use of a wireless communication device. That fine range is $1 to $200. Again, do you want to plead not guilty to that? That's why they pulled you over.
I play guilty. I'll play guilty on all of them because I did have no license plate. I was on my phone.
But you said it was an unlawful search.
But I want to do my lawful search. I guess I might have to, because that will help me do my lawful search on them, right? To get my case and my attorney to get the lawful search. I would like to do that. And I'm
So
sorry.
today you're gonna plead not guilty on everything. Use of a wireless communication device. So when you're leaving the jail, you're gonna sign 5 PR bonds. You don't lose your jail credit by pleading not guilty. I'll still look at all your jail credit. You're
Yeah,
gonna
I
be
would-
processed out today and you're gonna sign 5 PR bonds on each of the charges you got. No, 4, 5. No driver's license is the 5th. Okay, so on the bond, it's gonna tell you, wind up here at my courthouse. The deputy in the back has a map with directions. I know you don't like coming to my courthouse because you didn't come after you got out of jail the last time.
I did get into some shit, and I'm sorry for cussing, but I got into some family problems and I ended up getting shot not too long ago. And I've been working at Whataburger and they have me at 40 hours a week. Like I did try to get my charge taken care of at Potter. I called and was gonna get a walkthrough. And work my job didn't want to give me no time off. And I barely, like right now, I'm barely fighting with them right now to keep my job with them. I
I
work
bet
at
you
Whataburger. I work at Whataburger on Georgia Street. I work 40 hours a week. And I'm trying to take care of all my stuff because my grandma don't want me to be in jail.
Okay, so today when you leave, you're gonna sign those bonds. They'll give you a date and time to appear at my courthouse. Don't miss it, okay?
She's actually saving his tuchus right now because he has higher charges. I'm assuming when they searched his vehicle, what he's calling an unlawful search, which it's not, but he believes that it is. When they searched his vehicle, they probably found something. And so he's facing higher charges in another court. These are the least serious of his charges. So by pleading not guilty, the prosecution can use these charges to, as leverage to drop them and amend the higher charge. So she's really saving his butt. Because if he pled guilty to all of these, then there would be nothing to bargain with the prosecution.
In any way I could have my bondsman pick up those bonds for me?
Say that again?
Is there any way I could, because on the bonds, I already on bonds, is there any way I could put my bonds on those, with those?
No, you don't want to pay him for my 5 bonds. My bonds are separate than those bonds. You've got a bail bondsman on those charges from Potter County, and you don't have a bail bondsman on mine. Mine don't cost you any money. If you put him with my bonds, then you have to pay him for them.
No, it's just because I might want, that's what I feel like wanting to do, because last time I had a PR bond, I went through all the process and nobody, I tried to get my court date, it was nothing. I
But
called
when you're leaving the jail, it gives you a court date. Just don't miss it, okay? You can do it. If you work at Whataburger, you cannot miss a court date that you signed.
I let my boss know, and my grandma and my mom, she's very strict with me right now. That's who's
I bet.
taking care of my mom. She's in prison time. She used to be an ex-drug addict, so she knows. And she sees it going in a bad path, and she doesn't want that.
Okay, well, I bet she's pretty unhappy with you right now. You
Yes,
can
ma'am.
return to your pod.
So I'll be released here in an hour or so?
Sign the bond and get your date.
Yes, ma'am. Thank you so
Okay,
much.
thank you.
Let me go home today. Thank you. You have a good
I'll
Thanksgiving.
see you next week.
Yes,
Mr.
ma'am.
Jackson. Mr. Jackson, the charge from April 13th, 2015. Do you remember it?
Yes, ma'am, I do.
Drug paraphernalia possession of a socket. That fine range is $100 to $500. Do you want to plead not guilty because you want to hire an attorney or have a trial?
I'll go ahead and plead guilty on that, ma'am.
Wait. I'm sorry?
Plead guilty on that. I went to prison for 10 years, like, when I got arrested, and I didn't get out of jail for 10 years, so I'm trying to.
On your guilty plea, fine and court cost is $616. With $300 jail credit, you still owe $316. Is there any reason you cannot appear at my courthouse on Monday? Be here at 1:30 for the hearing at 2.
Yes, ma'am.
You understand what happens if you fail to appear?
I've been sworn for arrest.
You would. It would be called a capious warrant. Next time you'd sit it out, you'd be in jail a lot longer.
Yes,
Okay, do you know where I'm located?
Tyler Street?
4th Street side of the Amarillo Police Department. I'll see you Monday. Be here at 1:30 for the hearing at 2.
Ma'am, thank you.
All right, see you soon. Brett Kashuba.
Yes, ma'am.
This charge is called public intoxication. The fine range is $100 to $500. Court costs are $81. Now, it makes sense to me because I'm familiar with the law, but sometimes to people, it doesn't make sense. It has extra consequences outside of just the fine amounts that we're talking about. It has consequences to your driver's license. The law says that if somebody's convicted of public intoxication, you get convicted if you either plead guilty or no contest, or if you're found guilty at trial, then the law in the state of Texas tells me as the judge that I suspend your driver's license 30 days, beginning 11 days from the conviction, and I order you to take an alcohol education class and do alcohol-related community service. So I know that to you who is in jail, that's a lot to be thinking of. And so that's yet another reason, if you choose to plead not guilty and come see me in person, it's a lot easier to understand what all your options are when I'm talking to you in person rather than in Zoom. But you've got to appear if you bond out, you can't miss that bond hearing day.
Right.
And then I will talk to you about maybe what happened if you want to set it for a trial. If you don't want to set it for a trial, do you have a good driver's license?
Yes, ma'am.
Then we would talk to you about ways to try to keep that from hurting your driver's license.
Yep.
So do you want to bond out by pleading not guilty, or do you want to plead guilty or no contest? And then when you come and see me about your balance, I'll talk to you again about those consequences.
I'll plead guilty.
Are you sure? I'm going to suspend your driver's license. I'm doing my best to encourage you to plead not guilty and come see me.
I'll plead not guilty.
Because this is the first time you've had an issue. Have you been in Amarillo for long?
I mean, I've been here in Amarillo for 7 years.
Okay, so I know we're not familiar with you. Let me just look again to be sure that's true.
I've never had a charge or ever been to jail or anything like that. This is my first time.
Is your family here?
Yes.
Okay, so when you're leaving the jail, you're gonna sign a document called a personal bond. If you miss your bond hearing, you owe the city $500 in addition to still having this charge pending. So don't miss that bond hearing. It's like I said, it's a date and time for me to talk to you in detail about all the options that are available to you to try to avoid a driver's license suspension. Do you drive for work?
I don't actually. I don't have a car right now, so.
What do you do for a living?
Right now I'm actually bowing for Salvation Army. I'm homeless right now, so
You don't really have that address you gave my clerk. Is that your family's address?
yeah, that's the one on my driver's license and
Well, if I send mail there, is that a good address or not?
yes, ma'am, it is. My dad would just give it to me.
Your who would give it to you?
My dad would just give me the mail.
Why don't you get to live with your mom or dad anymore?
Because I used to smoke a lot of weed.
No, I would kick you out for that too. Okay, all right, so you're gonna sign a bond
Okay.
and it's gonna tell you when to appear at my courthouse.
This is when I need the Judge Boyd clip. Y'all stink.
Where do you usually stay when you're homeless?
Salvation Army.
So I'm walking distance from the Salvation Army, okay?
Mhm.
All right, I'll see you on the date and time of your bond.
Yes, ma'am. Thank you.
Mr. Luna. Okay, this charge is from June 4th of 2019. It's called tampering, change, modify, multi-channel video info system. That fine range is $1 to $500. Do you want to plead not guilty because you want to hire an attorney or have a trial?
What would be my best option?
Well, if you plead
That's
not
correct.
guilty, that's fine, but you've had a PR bond before and you missed your next court date. So you would have to call a bail bondsman to be sure you appeared for your court hearing. If you plead guilty or no contest, finding court costs are $604. I'm giving you $450 jail credit. So you would still owe $154 on that one. You would still have to come see me on the first business day after you get out of jail. So
That's
it
fine.
depends on whether or not you want to set it for trial.
I would like to do it where I come see you for the remainder of them.
Okay, so then to that, you either plead guilty or no contest, meaning you waive your right to a trial. How do you plead?
Guilty.
On your guilty plea, finding court costs is $604 with $450 jail credit. You owe $154. Now, these charges from January 12th of 2021 over on Georgia Street in a Buick LeSabre. Do you remember being pulled over by a motorcycle officer?
Yes, ma'am, I do.
First charge from that day is called no seatbelt driver. Fine range is 25 to 50. Court costs are $184. Do you want to plead not guilty because you want to hire an attorney or have a trial?
No, I plead guilty.
Okay, on your guilty plea, finding court costs is $234. Your time served. Secondly, you're not time served on this one. No liability insurance filed as a second. Fine range is $350 to $1,000. Do you want to plead not guilty because you had liability insurance that day, or because you want to hire an attorney or have a trial?
Well, what would be my best option on that?
Well, if you had liability insurance, you should bring it, or you can plead not guilty and set it for a trial. But
Well,
you said that you pled guilty to no seatbelt driver. So,
Oh, yeah, well, I didn't have insurance on that day.
so how do you plead?
Guilty.
On your guilty plea, finding court cost is $733 with $450 jail credit. So 733 less 450 means you owe 283. So you're not time served on that. Operating a vehicle with an expired plate, it was that Buick LeSabre. How do you plead?
Guilty.
On your guilty plea, finding court costs is $242. Time served. Lastly, no driver's license. How do you plead?
Guilty.
Okay, on your guilty plea, fine and court costs is $260, again, time served. Okay, so 154, 283, and then lastly, sold to June 4th of 2019, a drug paraphernalia possession of a joint over on Georgia Street. Do you want to plead not guilty? That was associated to that changing or modifying the multi-channel info system. How do you plead to the drug paraphernalia possession that day?
Guilty.
Okay, on your guilty plea, fine and court cost is $651, $450 jail credit. You owe 201. So 201 plus 154 plus 283. Hey, Karen, am I right when I say 638? So you have a balance that's remaining. Is there any reason you can't be here on Monday at 1:30 for a hearing at 2 to talk about how to pay that?
No, ma'am, I can be there.
And do you understand what happens if you failed up here?
Yes, ma'am, I do.
And you know where I'm located, right?
Yes, yes, ma'am, I do.
Don't forget about me. It's a long time between now and Monday.
Yes, ma'am.
So don't forget to come in because I don't want to see these turn into capias. Okay?
Correct.
Any questions?
No, ma'am.
Okay, I'll see you Monday.
All right, thank you.
Thank you. You can return to your pod.
Yeah, I came in here late last night. Does it say what pod I'm in? Okay, awesome.
This is in the District Court of Elk County, Kansas, case entitled State of Kansas versus Jet T. Hazelwood, case number 2021 CR 20. Jill Gillette appears as Elk County Attorney, Daniel Lamson as Defense Counsel, Jet Hazelwood appearing from the Elk County Sheriff's Office's Zoom location. This matter comes before the court at this time for hearing in regards to a warrant to show cause alleging probation violation, essentially failing to maintain contact with his intensive supervision officer and having his whereabouts unknown. Mr. Lamson, what are your client's intentions regarding this allegation?
Your Honor, I've just been recently appointed on this, and there wasn't, in my view of the e-file system, there wasn't a formal motion that set forth the alleged violations or a statement from the supervising officer. So I was unsure of exactly what was being alleged. I would like to have something formally filed and then an opportunity to either present a defense or admit that we violated. But at this time, I don't really know. I know that they're alleging that he didn't maintain contact or report as directed, and maybe they didn't pay the monies that were ordered. But as far as any more specifics to that, Your Honor, I don't have any information.
Well, the warrant itself only identifies failure to maintain contact with his officer, essentially not disclosing where his whereabouts were at the time. I myself don't have at least a paper copy of a request or a motion. Mr. Clausing, did you file a request in support of your warrant to show cause?
Yes, Your Honor. There was a request for revocation. I have it right here. I think I did. I don't
Does it
think
allege something different than the warrant itself?
no, that's pretty much what it says on the request for revocation, that he just failed to maintain contact with me. He failed to maintain contact basically through March and April of last year.
Okay. I think it's important to at least clarify for the record what your request actually says. Could you read the allegation language in the request? Verbatim, please.
My request?
Yes.
It's failure to report to intensive supervision officer as required. And I just wrote, the defendant has failed to maintain contact with his ISO and his whereabouts are unknown.
Okay. Not much different than the warrant to show cause language.
I apologize, Your Honor.
All right, Mr. Lamson, I do appreciate you taking this appointment, and I guess the allegation is relatively straightforward. And I'm not inclined to continue this case again. So if you need to confer with your your client, I'll give you the opportunity to do that in a breakout session, but do you need that
That would
time?
be great, Your Honor.
All right.
If you could give me a breakout session, that would be great,
All right.
Your Honor. Thank you.
At this time, then we'll recess briefly for purposes of allowing Mr. Lamson to confer with his client privately in a breakout session. Everyone else, please be patient. We'll rejoin the hearing very soon.
Had to have a little breakdown.
Am I back, Judge?
You are.
I think we're ready to proceed.
Just a moment, Mr. Lamson. We're recording and broadcasting again, Mandy?
Yes, Judge.
All right. Just wanted to make sure this was continuous. All right. Resuming proceedings in the Hazelwood matter. Mr. Lamson, you have an announcement?
Yes, Your Honor. After speaking with my client in that breakout room, we're prepared to admit that we did violate probation by not reporting as directed.
Very well. All right, Mr. Hazelwood, you've heard the announcement of your attorney, Mr. Lamson. You do understand, Mr. Hazelwood, that you do have a right to a due process hearing where the state would have the obligation of proving the violation by a preponderance of the evidence. You do have the right to challenge the state's evidence and present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and have you serve the remaining balance of your sentence locked up. Do you understand these things, Mr. Hazelwood?
I think so. Not really, but yeah.
Okay, well, don't say not really. I mean, either you understand what I'm telling you or you don't.
I understand that I could have to serve my whole sentence.
Okay, that's an important part of it.
Yeah, I know.
And that you're waiving a hearing in the case and you're stipulating or agreeing that you committed the violation rather than contest it. Is that what you want to do?
Yeah, I'm just trying to be honest and trying to work with you guys.
Okay, well, let me stop you there. So are you waiving a hearing in the case and agreeing that you committed the violation of failing to report to your officer?
Yeah, I just don't want to serve all that time in jail.
I'm sure you don't, but I'm just wanting to deal with this violation.
Yeah.
Okay, so yes, you are waiving a hearing and agreeing that you committed the violation like your attorney announced, correct?
Yeah.
Okay. Just want to make sure we're on the same page here, Mr. Hazelwood.
I'm just nervous. I'm scared.
Well, and you should be, but the court does find at this time that Mr. Hazelwood has waived his right to a hearing, stipulates and agrees that he committed the violation of failing to maintain contact with his officer and not reporting his whereabouts.
Yes, and telling him that he should be scared is probably not helping him right now.
Court does find this to be a substantial material violation of the terms and conditions of Mr. Hazelwood's originally ordered probation. We'll now turn to disposition of this warrant to show cause, and we'll start off, and I'm actually going to go to Mr. Klossing, his ISO. Do you have any recommendations that you wish to make in particular here, Mr. Klossing?
Your Honor, when I just wanted this case extended and have him do some type of small sanction, like a 3-day sanction. This is a first show cause. He's dealing with mental health. His mother passed away. He had some other issues. So and he lives in Longton. My plan is he now lives in Independence. So I'm going to transfer him. So I was just thinking a 3-day sanction and putting him back on probation, extending.
All right. When is his current expiration date?
It has already expired on this case.
And obviously this was a timely filed.
Yes, it was.
All right. All right, I understand your position. What is your office's position, Ms. Gillette?
Your Honor, we would be.
Okay, just a moment, Mr. Lamson. I'm asking for the prosecutor first here.
Oh, I'm sorry.
Judge, Mr. Hazelwood's mom did die. There was a lot of issues going on with the whole family at that time, including lots of usage. We actually had a search warrant at the Hazelwood home. He was not there at that time. What I am asking is that there be an extension of his probation, a sanction for him for not reporting as directed, and that he have an added condition that he have a mental health evaluation and that he follow up on all recommendations in his mental health evaluation. The only thing that's going to help Mr. Hazelwood is mental health treatment and drug treatment. So I believe that if he is getting mental health help, that it would go a long ways for him in combating the underlying problem for his usage. So if the court would extend him for a period, I was trying to determine whether I wanted to ask for 9 months or 12 months. I'd like him to do his mental health and sign releases for Mr. Clausing. So I'd like that added as a condition of his probation.
I have said it 1,000 times probably on this channel. We don't have a drug problem. We have a mental health problem. I really appreciate the courts that make mental health treatment almost mandatory for anyone who has a serious drug-related issue. Because mentally healthy people typically don't bury their problems in dope or alcohol. They have coping mechanisms. Now, don't get me wrong, it can happen to anyone. But typically there's an underlying issue. And I just wanted to take a moment. If anybody in Kansas or in the Kansas courts ever happens to see my channel, I just want you to know that I appreciate that you make the defendants with drug problems take a mental health evaluation and follow the recommendations for it as a condition of their probation, because it really is the only way that we are going to combat this crisis.
Well, thank you. Mr. Lamson?
We would have no objection to the extension of his probation for 12 months, Your Honor. I think added mental health evaluation or drug and alcohol evaluation would be beneficial to my client. So we would not object to those be added conditions of his probation. We would ask for a 2-day sanction, 48 hours. We would ask that he be allowed to report on the Saturday following Thanksgiving to begin that sanction. He served that and then be reinstated back on probation. And then whether he reports in Independence or he reports in Howard would be up to the supervising officer. But either way, it would be fine with us.
Why Saturday and why not right now, Mr. Lamson? What's your rationale for the... Go ahead.
He was just wanting to serve Thanksgiving with his family and then go to report to do a sanction. He knew there was going to be time, whether it be his entire time or a small sanction. He was just hoping to do his holidays with his family.
Very well. This time the court will address the defendant personally, and I'll ask Mr. Hazelwood if he has any statements that he wishes to make in mitigation of punishment here.
What do you mean by that?
Anything you want to say to the court about this?
I'm sorry for not reporting, and when my mother died, it really affected me in a really bad way, and I've been needing help really bad. And to be able to spend time with my family tomorrow it would mean the world to me. And that's I'll come and do however much time you want me to afterwards. It's just I already have plans, and that's all I've wanted to do is just to go be around my family so bad. And it's like after losing my mom, it's so hard on me, and I don't understand it. I'm a completely different person now, and I just if I could just go be with my family tomorrow, I'll even come Friday. I don't care. I'll come whatever day. I'll come after Thanksgiving dinner. I just would love to spend time with my family and be around them and get to see them. And I never meant to just fall off the way I did. I tried my hardest to not fall off and not just completely lose who I was. And it's just it's been so hard on me. My mom was like my only lifeline to the world. Like she helped me with everything. I've never been completely normal. I've always struggled my whole life, and she was always the one there that would help me, like call me and say, "Hey, you need to report. Did you report today?" And when she was alive, yeah, I was living at her house, but right when she went into the hospital, I had moved out. And I don't know. I'm having a hard time talking because I'm so nervous, and I just really want to spend time with my family tomorrow. I really do. There's no other reason than that.
Jet, do you have a phone?
Yeah, I have a phone now.
Do you know how to use it?
Yeah, not really. No,
You really don't know how to use your phone?
It's not that I don't know how to use it, but I can't make phone calls for some reason. It's so hard to answer anybody's phone call or pick it up and make a phone call. It gives me the worst anxiety ever. Like I don't understand it now. I really don't. I don't know what's wrong with my head. The only thing that's happened is losing my mom, and it's like
my point is that that's all you had to do to communicate with the community corrections officer is just make a call and let him know what's going on with you. And I have no doubt that he would have worked with you in a very reasonable way. It is your failure to contact him whatsoever that leads you to be here today. You understand that, don't you?
Yes, I'm almost positive I at least texted him. I mean, I'd always at least text him. Like if I couldn't mustered up the courage to make the phone call for whatever reason I can't, I always texted him. Like I always tried to say, hey, I don't think I'm gonna make it up there today, or we're having car problems, or whatever it was at the time. I at least would text him at least every 2 weeks.
I wonder about that. Nevertheless, we are where we are, Mr. Hazelwood.
I know.
You have my condolences over the loss of your mother. It was obviously an event that had a huge impact on you. But let me remind you that as you go through life, there's going to be stressors. There's going to be constant stressors. And you have to deal with them in an appropriate way. And just not communicating with your community corrections officer when you know that that's a requirement to keep you out of jail is a big problem.
I know. And it wasn't like it was just him that I wasn't communicating with. It was everybody. It was the whole world. I still can't like look at any pictures of my mom. I can't get on Facebook and scroll through anything because I'll end up seeing a picture of my mom, or it's so hard on me. She was my everything.
Right. I seem to have lost Mr. Klossing from the meeting. It's regrettable, but I'm going to go forward here, Mr. Hazelwood. I just want to make sure that if you are reinstated on probation, Mr. Hazelwood, that you're going to be making a bona fide effort to comply with conditions, including communication with your supervising officer.
I will for sure. I mean, I've came to every court date, haven't I? And I've contacted him every time I've needed to.
Well, except for the
besides
that you didn't and led you to be here today.
But since I got out of jail, when I got arrested for that, I've kept in contact. I've been doing what I needed to. I've been trying to get over to Ford County. I've just been having a hard time. My girlfriend works all the time.
Okay.
And she's my only ride. And I mean,
all right. There needs to be a sanction for your non-compliance here, Jet.
Yeah.
Regardless of any other problems that are going on, you still need to consider this a priority. And when you don't, there's going to be a sanction imposed. I
Right.
think I'm going to follow Mr. Lamson's suggestion here, and the court's going to impose a 2-day dip.
Thank you.
But I want you to be at the Elk County Jail at 9:00 a.m. on Saturday, November the 30th, to do that sanction time.
Thank you so much.
I, like you, want you to have the support of your family and to be able to celebrate Thanksgiving with them.
Thank you so much.
I hope I don't regret that decision.
You won't.
I would regret it if you don't show up when you're supposed to.
No, I'll be here.
9:00 a.m., Saturday, November 30th, for a 48-hour consecutive period. Be released 48 hours after your reporting. And then you're reinstated on community corrections. All unsatisfied conditions remain. I will extend you through the date of July 31 of 2025.
Okay.
Court will further order as an additional condition of probation and condition of reinstatement that you obtain a mental health evaluation from an approved provider, and I'm glad I have Mr. Klossing back. I'm going to ask Mr. Klossing to make recommendations, not today, but the next time he sees you, regarding mental health provider for evaluation and further treatment.
Okay.
Okay. He is in touch with, I think, resources that may be available to you, and I know he'll make sound recommendations to you about what you need to do to meet this mental health evaluation requirement. At absolute limit, I want the evaluation to be done within 45 days from today's date.
Okay.
And if it can be scheduled much sooner, that's what the court would envision. Mr. Hazelwood, I think you've recognized that you've got some issues you need to work through.
Yeah.
I can see the same thing. You need to get some professional assistance to guide you through this difficult time.
For sure.
And I don't want to have to see you again on a probation review.
You won't.
You need to successfully complete this in all material respects.
Judge,
Mr. Hazelwood, are you working?
Yeah, I've been working at this place called Bearded Construction in Independence. You just do home remodels.
Okay. And so how much money do you make doing that?
Not a lot.
Okay, what is not a lot? Come on.
Maybe $500 a week. I've been trying to look for something different. My mental health, it stops me from so much. I don't get to live life at all hardly because of it.
All right. The court is going to assess a $100 bids application fee here and an additional $100 in legal fees for an additional $200 to be added to his account that he owes. I'm going to waive any remainder. I have no doubt that the aggregate of legal services will be far beyond that, but I'm going to waive anything over this $200 amount that I've imposed here today.
Thank you. Where can I find that? Like, how do I pay on it exactly?
You haven't paid on your case at all?
I don't know. I was trying to look into it earlier.
Okay, well, contact the clerk of the district court of Elk County, Kansas, and they'll give you direction regarding forms of payment and manner of payment, okay?
Okay.
Clerk of the district court, not the clerk of the county, the clerk of the district court.
Of the district court?
Because we're dealing with the court.
Right.
Okay.
Okay.
Judge, can we have an order that he sign all releases for his mental health as directed by Mr. Klossing?
So ordered by the court.
What does that mean?
Your officer will explain it to you.
Okay.
He needs to be able to get information regarding your care. You need to sign releases to assist him in doing that.
Okay.
Okay?
Yeah.
He just needs to know what's going on with you.
Right.
All right. Mr. Lamson, is there anything else from your perspective that we need to address here?
I don't believe so, Your Honor.
Ms. Gillette, anything further at this time?
I don't believe so, Your Honor.
Mr. Clausing, do you need anything else from the court? Okay, I see his head shaking no. Mr. Hazelwood, do you have any questions about the court's orders?
No, okay.
When do you have to report to the Elk County Jail, Mr. Hazelwood?
At 9 o'clock on Saturday.
All right, that is the correct answer. You might even want to write that down and remind yourself, okay?
Let's have something to.
And Mr. Hazelwood?
Yeah.
Two things.
Yeah.
I really do hope that you're successful on this stage of your probation, whether it's supervised by the local office or some office that it's transferred to. I hope you're successful. Second thing is, happy Thanksgiving. Enjoy it with your family.
You too.
You've received a break, and I hope that you take advantage of this opportunity that you've been given.
Thank you so much.
All right. If there's nothing further then, this time the Jet Hazelwood matter will be in recess, and this meeting may be ended for all.
A rare glimpse into Judge Ricky having a soft heart. That was amazing. I don't think taking that kid away from his family would have helped him right now. I think that would have caused a lot more pain. Being the first Thanksgiving without his recently passed mother, the first holiday is terribly hard. He needed his family. And good on Judge Ricky for recognizing that. I really hope that this kid uses this as a stepping stone to learning how to be more independent and managing his own calendar without needing his mom to remind him. He can just pretend she's reminding him when his calendar alarm notification goes off, you know? I really do hope the best for that kid.
This is in the District Court of Greenwood County, Kansas. Case entitled State of Kansas versus Jessica Danielle Smith. It's case number 2020 CR 93. Jessica Smith appears from the Greenwood County Courthouse's Zoom location. Jill Gillette appears as Greenwood County Attorney. Joseph Favre is Defense Counsel. This matter comes before the court at this time for hearing on a warrant to show cause alleging probation violation. The allegations of the original warrant are failing to report as directed on August 1 of 2023. Haven't made any payments toward fines, court costs, or probation fees. Failing to report correct information regarding her employment. What are your client's intentions regarding these allegations, Mr. Favre?
Judge, in regards to those allegations, Ms. Smith will waive her right to an evidentiary hearing and stipulate what we would like to note that there's some discrepancy on that last one about the timing and the dates of that, but she acknowledges that she does not have that job. So we'll stipulate to all those.
All right. Are you aware of the addendum to the warrant to show cause that Ms. Morgan submitted to the court?
I am, Your Honor, yes.
All right. In your position regarding the allegation that she had been convicted of a new crime, interference with law enforcement, in Franklin County, apparently?
That is correct, Your Honor, and she acknowledges that as and also that is a violation of her probation. So.
All right. And while apparently the other matter that's been referred to in the warrant to show cause, apparently she's been charged in Franklin County with murder in the first degree.
So, Judge, that was dismissed as part of the plea deal in the interference law enforcement. She cooperated with Franklin County and even gave testimony in the trial of the person that was ultimately convicted, I believe, in that case. So she pled to the interference law enforcement, and that charge has been dismissed.
All right, Ms. Morgan, can you confirm that?
Yes, Your Honor. She is now on community corrections with Franklin County.
All right, Ms. Smith,
Yes.
based on your attorney's announcement, he's indicated that you now intend to waive any formal due process hearing that you'd be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence, and confront the state's witnesses unless good cause was shown. Among other lesser remedies, the court could consider an outright revocation of your probation in this case, and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes.
Do you waive a formal hearing in this case and stipulate and agree that you committed what appears to be 4 different violations that we've outlined here on the record?
Yes.
Court finds that the defendant in the case is knowingly and voluntarily waived her right to a hearing in the case and stipulates and agrees that she committed the violations of being convicted of a new crime in Franklin County, failing to report on one occasion, failing to report correct information regarding her employment, and not making any payments toward her fines and court costs and other amounts owed in the case. These are substantial and material violations of the terms and conditions of the defendant's probation. We'll now turn to disposition of this matter. What is the state's attorney recommending regarding a disposition of this warrant to show cause?
Your Honor, our recommendation is that she have a sanction, and this is her first time up here. She's been in custody for a significant amount of time on the case in Franklin County. So with her sanction here, we would ask that there be a modification at the end of the sanction, that she be raised to community corrections. We would ask that her probation term be extended. I don't know how much time she had left, but I was going to ask for 8 months from today's date, so that she has, and I'll leave it up to the court if it's a 2-day or 3-day sanction. And her case in Franklin County was ordered consecutive to this one. So though we had a hold on her, our warrant was actually issued before she was arrested in Franklin County. So it was outstanding at the time that she was picked up. So they did order those consecutive. So she would only get the jail time credit on one of the 2 cases. All that credit was written on her Franklin County's journal entry. Due to their journal entry controlling the concurrent or consecutive, due to ours already being sentenced. So it's my understanding that whatever sanction she has here today will go to her underlying, if she would have to serve anything here. So no, with all that knowledge, we're asking for a sanction, an extension for 8 months, and to order her modified up to community corrections. And after she reports to community corrections here, she can apply for a transfer so that she's only being supervised by Franklin County's ISO if they will accept the transfer of our cases as well up there.
Very well then. Ms. Morgan, do you have any recommendations to this court independent of what the prosecutor has recommended?
Your Honor, I'm in agreement with the state's recommendations.
Very well. Mr. Favre, your recommendations regarding an appropriate disposition.
Judge, I'm also in agreement with the recommendations by Ms. Gillette. I would ask the court to note also that in Franklin County, Ms. Smith does not have much criminal history. She was given Senate Bill 123 treatment in that case, and she's going to be doing a drug treatment program from what I understand. Ms. Smith, additionally, this is her first time before the court, obviously with what are some potentially very serious allegations, of course. But Ms. Smith, this is her first time. We would ask the court to consider those when granting its order. We would also note that Ms. Smith is there with family, and we'd ask the court to consider allowing her to schedule those 2 days in a couple weeks so that she's not missing her Thanksgiving holiday, but again, we'll leave that up to the court. That'd be our request.
Thank you. I appreciate you and the prosecuting attorney allowing the court to be in charge here, Mr. Favre.
You're welcome, Judge. Sorry.
All right, Ms. Smith, let me address you personally, and I'll ask you, do you have any statements that you wish to make here in mitigation of punishment?
No, sir.
Smith, there's some serious concerns here with what's currently before the court. The court would be concerned that you don't take reporting to your probation officer seriously, that you don't take your payment requirements seriously, that you don't take honest and fair reporting to your officer seriously, and that you don't take the court's fundamental condition of probation about observing all laws very seriously. You're apparently involved in a very serious matter in Franklin County while you're on probation in this case. It does make the court wonder how successful you're really going to be on any probation program. There's just a number of deficiencies here which the court has obvious concern about. Court will, as a sanction for noncompliance in this case and consistent with the graduated sanctions scheme, which is supported by legislation in Kansas, the court will impose a 3-day dip sanction in this case. You're going to say something, Mr. Favre?
Oh, no, Judge, no.
Okay, I thought I heard your voice.
No, I was muted. No.
Okay. A 3-day dip. Ms. Smith, I think I'm going to test you a little bit here. Okay. And I'm not going to do what I do in a vast majority of my cases and impose the sanction to be immediate. Okay. I do know tomorrow's the Thanksgiving holiday. Do you have a family member there with you?
Yes, I do. That's my mom.
Would it be your intention to spend Thanksgiving with your mother?
Yes.
Court's inclined to allow that, but I mentioned earlier that I'm going to be testing you, Ms. Smith, because we're going to set a date of you to report at 9:00 a.m. on Friday morning.
Okay.
To serve 72 consecutive hours. Because we're not doing it today, the court feels like a 3-day dip sanction is appropriate, as I'm deferring this to benefit you and your family.
Thank you.
But it will be a 72-hour dip sanction to begin at 9:00 a.m. On Friday morning.
Okay.
Which would be November the 29th. Now, don't be late and don't miss this.
I won't.
Some people have made that mistake, and guess what? They end up doing a lot more time.
I don't want to do that.
I'm sure you don't. So hopefully someone can deliver you to the Greenwood County Jail Facility.
Yes.
9:00 a.m. Friday, November 29th for a 72-hour dip sanction. Then I will reinstate your probation. Any previously established condition remains in effect. The court will transfer supervision to community corrections and will extend your probationary period through the date of July 31 of 2025. Are you currently working, Ms. Smith?
I have a job lined up with Focus, which is at American Eagle there in Ottawa. So, and it's normally a weekend shift, or it's supposed to be a weekend shift. So, but I mean, I can still show up this Friday. Like,
okay. Well, that you don't really have a choice on that.
okay, yeah.
All right, that would lead to your release being Monday. The court's going to direct that you then, upon being released, which should be about 9:00 a.m., obviously, that you go to the community corrections office. Will they have an officer there in Greenwood, Ms. Morgan?
I believe that Ken Clausing only comes on Thursdays, so she would have to report, but I can help assist with whatever I need to do to help with that.
Well, I really want her to see a community corrections officer. I will direct Ms. Smith then, upon your release, that it is incumbent upon you to contact the community corrections office in Greenwood County. Jessica, do you have that number handy? I can look it up.
Judge, they call the Butler office to for scheduled appointment.
All right. Call the Butler County Community Corrections Officer upon your release on Monday. And then they'll give you further direction about getting started with the community corrections program. All right, Ms. Gillette, is there anything else that the court needs to address?
If you're assessing any fees for today.
I'm not. Ms. Morgan, are you aware of anything further that needs to be addressed or clarified?
No, Your Honor. And I also will go down and give her the number to community corrections.
Thank you. I appreciate that. Mr. Favre, anything further at this time?
No, Your Honor. Thank you.
Okay, and again, Ms. Smith, do you have any questions about what we've done here?
No, sir.
Okay, 9:00 a.m. sharp, Greenwood County Jail. You need to surrender to serve your 72 consecutive hours of dip sanction.
Okay.
And I hope you're successful on your probationary program from here with community corrections.
Thank you very much, sir.
All right. There's nothing further then. The Jessica Smith matter is in recess. And this meeting, this is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Taylor Lee Summerland. It's case number 2021 CR 132. Richard Paw appears as defense counsel, Jill Gillette as Greenwood County attorney.
Do you guys remember the guy who called Jill Gillette on her personal cell phone, or had the jailer, I believe it was, call her? That's this guy.
Taylor Summerland, with the agreement of the court, appears remotely by Zoom. This matter comes before the court at this time for further proceedings in regards to a warrant to show cause alleging probation violation. Mr. Paul, what are your client's intentions regarding these allegations, which include failure to contact his ISO as directed, failure to provide verification of his substance abuse treatment?
Judge, after speaking with Mr. Summerland, he will waive his evidentiary hearing, admit to the violations with explanation, and proceed to disposition in this matter, Your Honor.
Thank you, Mr. Paul. All right, Mr. Summerland, you have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, present your own, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and order you to serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, sir.
And do you waive a hearing in this case and stipulate and agree that you committed the violations which the court outlined earlier?
Yes, sir.
Judge Ricky brought out his dad voice for this one.
All right. Court finds that Mr. Summerland has waived his right to a hearing and stipulates and agrees that he committed the violations as alleged, failing to provide verification of his substance abuse treatment and failing to contact his ISO as directed are both serious and material violations of the terms and conditions of his probation. We will turn to disposition at this point, and I'll take recommendations from the various persons involved, beginning with Jill Gillette, Greenwood County attorney.
Judge, Mr. Summerland has had a long road in history in these matters. And this is not his first revocation. He had a revocation in December of 23. He had to contact Mr. Catley then. Needed to be following Mr. Catley's orders. So we've had quite a few issues when it comes to Mr. Summerland. He's now over at Bel Air. This is one of those cases where everyone has gone above and beyond for Mr. Summerland. This, I don't know if you remember, was the individual that was on fentanyl and meth at the same time. He had methadone. the doctor at Holland Pathways wanted to wait a week before accepting him. The sheriff went all the way over and got his meds from the clinic in Wichita to give him in the jail, and then he refused to take them in the jail. Lots and lots of stuff was done for him for his last revocation. He's back in treatment again today, but I don't know how long it's going to last. We're up here on another time of him not following the directions of the court, not following his court services. He had failed to report his intensive supervision officer as required. He was supposed to be contacting every Friday via phone and has failed to do so and absconded in March. His whereabouts were unknown at that time, and he failed to provide verification of his substance abuse treatment he was supposed to go to, which was all that mess we did in December for him. And he didn't complete it and didn't get all the information turned in to Mr. Ketley, and his ISOs out of Wichita have had issues with him. They've bent over backwards for him. If you remember and recall, Mr. Gonzalez did all kinds of things to help. And I am basically at a loss of what to do other than to ask for him to serve his underlying. If the court or Mr. Ketley recommends that he have sanctions and that he be reinstated, I'm going to leave it up to Mr. Ketley. Mr. Gonzalez has had to work with him out of Sedgwick County, but he just up and absconds every time and then doesn't complete his treatment. What's to say he's not going to walk out again tomorrow? And after everyone basically moved mountains because he begged and pleaded last time, he didn't comply with all of that either. So right now he's in Holland Pathways again, but for how long? And that's where I'm at, is he talks the talk, but he cannot walk the walk. And so I'm basically saying he needs to serve his underlying.
Very well. Mr. Ketley, the court has a question. Obviously, his original probation is expired by now.
Correct.
When was it extended, and when was it extended to? Perhaps Mr. Gonzalez can address it.
I believe he was extended until December 22 of 24.
Mr. Gonzalez, can you confirm that?
Bear with me just one moment.
And was that done as part of the order which stemmed from the last revocation proceeding?
Yes, at the violation hearing on December 21st, you ordered a 12 months extension from his original termination date.
Okay.
Right, and I show his termination date effective 12/22/2024.
Thank you. Appreciate that, gentlemen. All right, Mr. Ketley, do you have any independent input here?
No, Your Honor, I agree with the state. I mean, I didn't put near as much effort into it as Mr. Gonzalez did, but I know he spent a lot of time trying to help Taylor, and Taylor just, he'd do okay for a little bit and then he would just take off.
Mr. Gonzalez, anything that you wish to say?
Not at this time. It sounds like he's not putting any effort into his recovery or probation. I find it convenient that he is now entered inpatient treatment again right before appearing in the court today.
Very well. Thank you, Mr. Gonzalez. Mr. Paw, your recommendations regarding an appropriate disposition here?
Judge, Mr. Summerland would ask me to ask you to put him back on probation. Judge, back in March, he lost his job and he found himself homeless. He sold his phone so he could eat. According to Mr. Summerland, he had asked Mr. Ketley to move him to 905 Corrections there in Sedgwick County, because that's where Mr. Summerland was living, because he physically couldn't go to Eureka or basically out of the city of Wichita. So, Judge, and I'm sure Mr. Summerland would like to address the court as well, but Taylor has re-engaged in treatment. I've talked to his substance abuse counselor, Sarah Poole. She thinks that he is back on track, but I know it looks suspect to the court that he comes in just a couple weeks before having to face you, Your Honor, and I would acknowledge that. So the judge, he's 25 years old. He's had a lot of substance abuse issues. I think deep down he wants to do the right thing. He just when he gets a hurdle, it just kind of shuts him down a little bit. So, Judge, that's all I have.
Mr. Summerland, I'm going to address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you personally would like to present to the court.
Yes, I definitely recognize what this looks like on paper. And I made an effort when I saw this was coming after I lost my job. And before I even lost my job, I told him on my very first meeting that at some point I'm going to need to be switched to 905 because I don't have the means to go back and forth. I told him before it ever happened that I'm struggling financially. I don't always even have money for food, let alone my phone bill. So I requested more than one time to be transferred to 905, and it just kept getting kicked down the road. And when I lost my job, I was already so far behind on my bills that since I was subletting, I was out on my, pardon my language, I was out on my ass immediately. And I made it maybe 4 or 5 days, and then I sold my phone so I could have something to eat. I lived in a tent.
No, let me stop you there. What is your understanding of this term 905?
Sorry, it's the parole office here, somewhere that I could physically go. The 905 building, it's 905.
You're not on parole, are you?
No, it's corrections, but that's where like I would meet Derek. That's where the building he was housed in. I asked if I could, have access to that so that way I could still report because I knew there was going to be issues with my phone contact. I saw that coming down the line, but after I got put out, I had nowhere to go. I couldn't go to my mom's in Eureka because she's not clean. I couldn't be there. And the only reason that I came back to rehab was because I didn't realize that when Holland electively switched me to outpatient treatment, that wasn't considered a successful completion. Like I had no idea because they switched me to outpatient. And then when I lost my job, I had no way to get there. But in my mind, I had already finished. I was 90% of the way through the program. I wouldn't have just left. And I didn't have anywhere stable to go after that. I was living at the whim of my employer. Like I didn't have anywhere to go. I did not want to leave. Like when I left, I went because they said, okay, this is what your insurance is going to cover. And, we'll still be able to take care of you in outpatient treatment. You'll see us 4 or 5 days a week for this many hours a day. And I was like, okay, well, I guess I'm comfortable with that, I don't really have a choice in the matter. And at the time there was family motivations as well. That was, my daughter was not getting taken care of as good as she could have been. So I left to help so I could start making money again. I didn't just electively like, oh, I'm done with this. So like, I understand what this all looks like on paper, but that's simply not what actually happened. And the reason that I agree with what you guys are saying is because you guys did bend over backwards, but I didn't just blow this off. Like I got the rug pulled out from underneath me and I did everything I could to fix it. And to be quite honest, I didn't expect to live long enough to have to answer to this. I wasn't trying to live. I lost everything all at once. I'm not looking for a pity party, but I definitely don't agree with what you guys described that I did. That ain't true. And you should be ashamed of yourselves.
Judge, this is the same individual who ended up calling my cell phone number from the jail after the last revocation hearing.
For what purpose?
Because he was refusing his meds and were angry that they were making him take the meds. They went to extra lengths to get him, and Mr. Gonzalez and Mr. Ketley and the sheriff worked so hard to get him his anti-seizure med and his methadone to help him break the addiction to fentanyl. And he started refusing them in the jail right after we went and got them all for him and tried to help him extensively. So then he got a jailer to call my cell phone number to complain that he was being made to take his meds to help him medically so that he didn't have more seizures. So I don't want to hear any more of this. This is all the same stuff we heard at the last hearing. This exact same stuff we heard at the last hearing.
May I respond to that?
You certainly may.
Okay. I definitely noticed that there was refusal for some of the meds because I wasn't allowed to take partial doses. And shaking your head doesn't mean anything. I was there. I was told by the rehab that I could not go to rehab until my dose was at 25 milligrams a day. And I was getting 50 milligram doses for one day. So I had to either break them in half, which wasn't allowed, or not take it at all. So I tried to push through and just not take it so I could go to rehab. Like, yeah, one of the motivations was I didn't want to be in jail, but I'm not trying to just say that I didn't want to take it. Oh, I don't care that you guys did this for me. That's just not fair. And I've never been homeless before in my life, so you can't say that that's what happened.
All right, all right. Hang on.
Your Honor,
Mr. Summerland.
Your Honor, I can attest to the fact that that was one of the requirements for him to get into Holland Pathways was a reduction in medication.
All right.
You have to a certain dose on methadone.
And at Bel Air, where I'm at right now, again, I only came here because I didn't know the completion wasn't like I didn't technically complete on paper, even though I went through the whole program. And Bel Air allows me to take my methadone. I never quit taking my methadone after I got outside of Holland. Like
I identify the facility that you're currently in.
Bel Air Recovery Center.
Okay. And are they affiliated with another provider?
No, my counselor says no, they're not.
How is it that you became admitted to what appears to be an inpatient facility?
I asked them to admit me. I came and I put the effort in to be admitted. Like, no one sent me here. I called admissions and I got myself a bed date.
All right. When did you check into the facility?
The 14th.
Judge, if I may clarify, I believe I sent a copy of a letter to your assistant and Miss Gillette from Bel Air Recovery Center.
All right. What is your expected out date?
The 14th of December, and that's a tentative discharge. That means that it could be before, it could be a little bit after, but no more than a week in either direction.
Based on the course experience, generally inpatient facilities best address people that need detoxification, somebody who's in the throes of serious drug addiction and are still using.
Yes.
But you're not supposed to be using at all, which is a message that we sent you 2.5 years ago when you were originally sentenced.
No, Your Honor, I absolutely did relapse when I tried to hurt myself. I tried to just finish it. That's what I meant by I didn't expect to have to answer to you guys. I was done. I had nowhere else to go, and I was living in a tent. I was ready to be done.
So what do you think should happen today, Mr. Summerland?
I think that this is a moment where everyone is mad at me, and I understand that, but I've never been in this position before in my life. Everyone just looks at it like it is on paper. I know I deserve another chance. I've been busting my ass to make this work. I've never once pretended like I didn't mess up, and I'm not sitting here and said, oh, pity me. And that's not true. That didn't happen. I've owned every single thing that you guys have said, every bit of it. But how it looks on paper is it's extremely robotic. It's not human. That doesn't account for what was happening. I don't know if any of you have ever lived in a tent, but I know what it's like to have to go find a bridge that's not adjacent with the wind so I could sleep, so I wasn't freezing. I know what it's like to go 4 or 5 days without food. That's what the last few months have been for me. I haven't been just living it up, absconding. I had to beg, and that just breaks you. I barely, I didn't expect to be able to get out of jail, but I called my ex-employer that was supposed to be helping me with the job, and he said, well, I'll bail you out, but you're working at an extremely low rate. And I didn't even, like, I was working for free. I was literally working for free. I didn't have anything or anyone. I was lucky to get a friend to let me stay on a couch one night a week, if that. Everything I own is in a duffel bag here. Everything I own. I lost everything else.
So wouldn't turning yourself in and being in jail be a better choice? You say you had no other choice, but you did. You'd have had meals, a place to sleep, and you'd have gotten clean. They do have group therapy and counseling programs and things like that in jail as well. The only thing you wouldn't have had would be the methadone. But you would have been able to get clean.
I had a car before that was mine. It got impounded, and I couldn't get it back. Everything I own fits in a backpack. And like I said, I don't have anywhere else to go that's safe for me. I didn't relapse while I was out on the street because I wanted to get high. I was trying to kill myself. This is callous. This is extremely callous. They're describing me like a crook. That's just not me. I've done everything I can to make this work. I told him before it was an issue that I needed to be able to report here or I was going to fail. I guess at the end of the day, you guys are either gonna hear me and understand what I was going through, or you're gonna throw the book at me. I don't have any control over that, but the way that it was described is not at all what happened. I
Judge,
own what I did wrong.
he's already been sanctioned once by the supervising officer for 2 days. The court sanctioned him, and then he's also been in custody with Harvey County recently in October. And he has had other law enforcement contact. So he has been at Sedgwick County and at Harvey County in the meantime. And the Sedgwick County dates were back in May, and the Harvey County was in October.
Respond to that.
A moment. Yes, you may.
Okay, those were all not new cases whatsoever. They were WAPT charges and stuff that got brought back up, and I didn't have an address for them to let me know that I had court, so it just went into bench warrant status. None of those were newly acquired charges. It was stuff that happened before. I didn't get in any trouble. They just came and got me.
And Your Honor, just to clarify, he was reporting to Sedgwick County till he was kicked out of treatment, and they sent him back. And I had him reporting by phone because I knew he couldn't make it over here.
Thank you, Mr. Kettler. Mr. Summerland, one thing that puzzles me is that I have in your file an appearance bond, which apparently was done over in Harvey County with the assistance of B&K Bonding out of Salina. This court had set on your arrest warrant to show cause $3,000 cash or surety. How does a penniless, homeless guy like you make that $3,000 bond?
Like I said, my ex-employer bailed me out so he could get cheap labor out of me. An obscene number of hours in exchange for me bailing you out at this. And that's exactly what happened. That's what I meant by working for free.
Very well. The court has heard all of the recommendations that have been made today. Mr. Summerland, in the interest of justice, this court is going to presuppose that there was an appropriate professional evaluation done of your then current condition, which led to you being admitted to an inpatient, essentially a detox facility, where you currently are. It also is logical that it's going to be one of those traditional 30-day programs where you would have an expected out date about December the 14th. Court considers it in the best interest of this offender and in the interest of justice to allow you to complete that. If nothing else, if there is benefit to be received from the program that you're currently in, you're essentially well into it. The court wants to see you complete it. Now, I don't know exactly how you're paying for it, and I'm not going to get into that. But I'm going to also presuppose that what you've represented here is correct and that you're going to be in this facility till approximately December the 14th. This court will therefore then defer its announcement on disposition until Thursday, December the 26th, which is my next Greenwood County court date. Mandy, can you suggest an afternoon time that we can resume proceedings in this case and the court can announce an appropriate disposition?
1:15 p.m.
Mr. Paw?
Doesn't make me happy, but I'll be there.
All right. December 26th, 1:15 p.m. Summerland, you're going to be out of there December the 14th or around that date. You should have no problem arranging transportation. I don't care if you have to ride a bicycle or even walk, but you're going to appear at the Greenwood County Courthouse in Eureka. I don't know where else you would participate from after you're released from the facility, and you're not going to be at the facility anymore. So the one place I know that you can participate from is the Greenwood County Courthouse in Eureka, Kansas. You're going to have to use whatever resources that you have available to you to make sure you're there. And only that location. It's the only one I'll approve. I am deferring your disposition, I think, to benefit you. Therefore, you will have 12 days to get yourself to Eureka and to participate from the Greenwood County Courthouse location on that date. And that is 1:15 p.m. on December 26th.
Understood. Your Honor, I don't know how else to ask, so I'll just be straight. Like, I've been looking into sober living places here. Is that something I should just not worry about doing? Because
we're recommending you go to.
At this point, I want you to successfully complete the inpatient program that you're in and show up for court on December the 26th at 1:15. I make no promises here.
Understood.
I just believe that it's in the interest of justice for you to complete this program that you're in.
Whoever is the individual feeding him information at the treatment facility shouldn't be doing so. He has an attorney to take care of legal advice.
So noted. I do appreciate the facility and their staff working with this individual that obviously needs their help and assistance. December 26, 1:15, with Summerland appearing at the Greenwood County Courthouse in Eureka, Kansas. This will be a Zoom proceeding for all other participants, but I want you to participate from that location. I have no doubt that they'll have effective Zoom audio and video for you to participate fully at that time, Mr. Summerland, even if you don't have a phone.
Understood.
Okay. Because he's in inpatient treatment, I'm not necessarily going to establish any reporting requirements between now and time of December the 26th, unless Mr. Gonzalez or Mr. Ketley specifically requests that. Okay, I see no. So just make sure you're in Eureka and ready to participate further in your dispositional phase of this proceeding, December 26th at 1:15, Mr. Summerlin.
I'll be there.
All right. If there's nothing further at this time, the Summerlin matter will be in recess, and this meeting may be on for all. This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Curtis S. Dixon, case number 2023 CR 89. Curtis Dixon appears without a lawyer. Jill Gillette appears as Greenwood County Attorney. Ken Klossing appears on behalf of the Community Corrections Department. This matter comes before the court at this time for a scheduled hearing on a warrant to show cause alleging probation violation. Court's looking at the notes from the last hearing. Show cause hearing was set apparently before Judge Webster on today's date, and defendant represented to the court at that time as he was hiring an attorney How come you don't have an attorney with you, Mr. Dixon?
I was having trouble coming up with the funds, Your Honor, and now he's on vacation.
Well, it's unacceptable for us to be sat here today for a probation review hearing and you not have counsel. It's just unacceptable in the view of the court. I hope this isn't just some stalling maneuver on your part, Mr. Dixon. We're going to go ahead and reset this hearing one time. I'm going to reset it to December the 26th. Mandy, I show 10 o'clock open. Do you?
Yes, Judge.
December 26th, 10 o'clock a.m. Mr. Dixon, you must again appear at the Greenwood County Courthouse in Eureka, Kansas, and no other location. I'm going to appoint a lawyer to represent you. Mandy, who is the attorney set to represent a defendant at 11 o'clock that day?
Ambrose.
Ambrose. I'm going to appoint Chris Ambrose.
He had Mr. Pate before.
I'll appoint Chris Ambrose to represent Mr. Dixon. Now, Mr. Dixon, you can replace Mr. Ambrose with your own retained attorney prior to the hearing if you so desire. But again, the court wants an attorney with you the next time this matter is scheduled for court. You're facing an outright revocation of your probation here. This is a very serious matter. And I want you represented at the next hearing in this case. 10 o'clock a.m. on Thursday, December the 26th. All right, I want to make sure I understand the current set of circumstances here, Mr. Clausen, and I know that some of this paperwork is dated. Allegedly, according to the warrant to show cause allegations, he did his initial intake back in June and never reported again until Officer Stanfield wrote him up about 4 months later. Has he been reporting since September?
Since his last show cause, he has been in contact with me. He has reported in person and has contacted me by phone. But that was
Is he set up for another appointment with you, Ken?
I'm sorry, Your Honor.
Does he have another appointment scheduled with you right now?
I don't think we do right now. I think the next appointment was this court hearing.
Well, let's get one on the books.
All right. Do you wish to set some sort of appointment with him between now and December 26th?
Yeah, how about next Thursday at 10 o'clock and in Greenwood County at the courthouse?
Mr. Dixon, did you note that?
Yes, sir.
Okay, you've got an appointment with the community corrections officer for next Thursday at 10 o'clock a.m. And we're talking about a week from Thanksgiving. All right?
Yes.
Make sure you make that appointment, Mr. Dixon, and follow the directions of your ISO between now and the time of the December 26th hearing. Let me ask you, Mr. Dixon, who were you looking at retaining to represent you?
John Barrett.
All right.
Goddard.
Well, you, again, have every right to retain your own counsel and replace Mr. Ambrose. Otherwise, Mr. Ambrose is appointed to represent you at the next hearing, December the 26th at 10 o'clock. Ms. Gillette, is there anything further that we need to address regarding Mr. Dixon at this time?
No, I was going to ask to have an attorney appointed even if he wasn't completely indigent so that he can reimburse that on the journal entry if necessary. But we had the same issue at the beginning of the case, and we had issues getting his PSI in this case.
All right, well, let's go forward from here. Mr. Dixon, make your appointments with community corrections. You'll have some sort of attorney representing you at the next hearing, December 26th at 10 o'clock, and then we'll address the allegations in the warrant to show cause. Mr. Clausing, do you need anything else from the court at this time?
No, Your Honor.
Mr. Dixon, any questions about what we've done here today?
No, sir.
All right, Mr. Dixon. We'll see you December 26th at 10 o'clock. Court is in recess at this time. This meeting may be ended for all. This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Tiffany Tyann O'Brien, case number 23 CR 147. Richard Paw appears as defense counsel, Jill Gillette as prosecuting attorney. Tiffany O'Brien appears by separate Zoom from her lawyer. This matter comes before the court at this time for arraignment. Apparently, the matter came before the magistrate court on October the 25th. Defendant waived preliminary hearing. Arraignment set for today. Mr. Paw, does your client desire the charging document to be read to her?
No, Your Honor, we would acknowledge copy and receipt of the amended complaint, waive its formal reading, and pursuant to plea negotiations, Ms. O'Brien is going to enter a no contest plea to amended count 1, criminal trespass, a Class C misdemeanor. She will plead no contest to count 2, theft, a Class A non-person misdemeanor, and count 3 will be dismissed. Parties are going to recommend there's going to be $50 of restitution, joint and several, a 6-month underline on count 2, a 30-day underline on count 1. We'll leave it up to you, Judge, if it's going to be concurrent or consecutive. 12 months of reporting probation, and we would ask for Ms. O'Brien now lives in Lyon County, and we would ask for a courtesy transfer to Lyon County, Judge.
Gillette, as Mr. Paw announced consistently with your understanding as to how this O'Brien case would be handled?
Yes, Your Honor.
What is the nature of the plea your client will be entering?
No contest, Judge.
All right, Ms. O'Brien, importantly, you've been on this meeting and you've heard your attorney's announcement. It would appear consistently with the state's agreement to amend count 1 from a felony charge to Class B misdemeanor criminal trespass. And then you'd be pleading to that, and then also the misdemeanor theft count in count 2, which is a Class A misdemeanor. Is that indeed your intention?
Yes, sir.
You understand that Class B misdemeanors are punishable by up to 6 months in the county jail and up to a $1,000 fine, or both?
Yes, sir.
You understand that Class A misdemeanors are punishable by up to 1 year in jail and up to a $2,500 fine, or both?
Yes, sir.
And it is your intention to enter no contest pleas and accept conviction to both of these misdemeanor charges?
Yes, sir.
What is the factual basis for the criminal trespass and the misdemeanor theft? As concisely as possible, Ms. Gillette.
Your Honor, on February 24th of 2023, individuals arrived at 308 Lincoln Street, Virgil, Kansas. One half of the block is the Virgil Co-op. The other half are extra buildings that are owned privately. One of those buildings was entered into. There was not permission from the owner, Kelly Sage, to enter into that building. There was a wooden crate removed from the building. The wooden crate had an approximate value of $50. It had unknown contents of the crate, but the neighbor, Jean Titus, was able to record the situation going on her iPad. It was caught on video. Another individual's vehicle was driven there by the other individual, and Ms. O'Brien was one of the individuals identified on the video to have entered the building with the individual that removed the crate, and the crate was loaded into the vehicle and taken.
Very well. All right, Ms. O'Brien,
Yes,
do
sir.
you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for amended count 1, criminal trespass, a Class B misdemeanor, and Class A misdemeanor theft in count 2?
Yes, sir.
Very well. Court finds that this is a free and voluntary act on the defendant's part. She's been made aware of the possible penalties, and there's a factual basis supporting each one of these charges. Defendant now stands convicted pursuant to the court's acceptance of her no contest pleas to amended count 1, criminal trespass, a Class B misdemeanor, and count 2, theft, a Class A misdemeanor. We'll proceed to sentencing at this time. What are the state's formal recommendations?
Your Honor, the recommendations were as stated by Mr. Paul. I am recommending for the criminal trespass, it's a B misdemeanor. I'm recommending a 30-day underlying sentence For the theft, it's a Class A. I'm recommending a 6-month underlying sentence. No objection to the 2 counts running concurrently. They're part of the same scheme and activity. The probation is recommended to be 12 months. I believe Miss O'Brien's on supervision, maybe out of Lyon County currently. She will need to report here, and then the probation may be transferred either up to Lyon County if she's still living there, or retained here if her other supervision is going to be transferred here, whichever direction where she's living. There is a $50 restitution on the box that was removed. It's joint and several with several of the co-defendants. There being, I believe, 4 of them. Those, the box restitution being joint and several may have already been paid because a couple of the co-defendants have been on supervision for a while. Court cost, probation fee, booking fee. I don't know what Mr. Paw's fees are going to be. This did start as a felony, so we would have to get bids as well. And there's no KBI lab fee or anything like that.
Very well. Mr. Paw, your recommendations regarding an appropriate sentence?
Judge, I would mirror the recommendations as outlined by the state. The only thing I need to do is address attorney's fees. I have approximately $400 in attorney's fees on this with the bids app. Ms. O'Brien reports to me that she is unemployed, has been for a little while, but is actively looking for work. So, Judge, I would just leave those fees at your discretion.
Very well. Tiffany O'Brien, at this time, the court will address you personally, and I'll ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present.
Okay.
Anything you want to say?
No, sir.
What kind of work have you done in the past?
Home health and CNA.
Okay, where do you currently live?
I live in Emporia.
Okay, Emporia is a big city with a lot of work opportunity.
Yep.
Okay, so what kind of work are you seeking in Emporia?
I'm seeking home health or factory.
All right, when home health workers make what kind of salary usually?
I'm not really sure. Probably $16 to $17 an hour.
Okay. If you're not working at this time, how are you supporting yourself currently?
I live in a sober living house, the Empire House, and I'm currently on drug court,
Okay, out of what county? Lyon?
Lyon County.
Okay, all right. Thank you for the information.
You're welcome.
In the matter of State of Kansas versus Tiffany O'Brien, the court will impose sentence at this time. For the conviction of criminal trespass, a Class B misdemeanor in amended count 1, the court imposes 30 days in the Greenwood County Jail. Court imposes no fine. Regarding count 2, theft, a Class A misdemeanor, court imposes 6 months in the Greenwood County Jail. The court will run that time consecutively to the time imposed on count 1 for an overall controlling jail sentence of 7 months in the Greenwood County Jail. Court will grant the defendant 12 months reporting probation to be supervised by Greenwood County Court Services until it can be transferred. Court does support transfer to the defendant's actual county of residence. We want to try to set her up to succeed. Court will be assessing a misdemeanor docket fee, misdemeanor probation fee, order the defendant to pay $50 in restitution to the victim in this case, Kelly Sage, joint and several with other co-defendants. Court will find at this case that when Tiffany is employed as a home health care worker, as she's apparently qualified to do, she should be able to earn enough money that to pay a bids application fee of $100 and $250 in legal fees. Any remainder is waived. Court determines that if paid out overtime over the course of her probation, that shouldn't work a burden or hardship on her or any family members.
And 100 bids and 250 attorney.
That's what the court announced. All right, Ms. O'Brien, we need to establish a minimum payment that you're going to start making.
Right.
We're here at the end of November. I'm inclined not to require a payment in December, but starting January, we need to establish an amount that you're going to start paying. What do you think you're going to be able to do?
Maybe 50 a month.
I think that's fair.
Okay.
Court will order a minimum of $50 a month, starting with January of 2025 and every subsequent month until the case is paid in full.
That's really nice of him to not start it until January, to let her get through the Christmas season. I really appreciate how compassionate Judge Ricky has been through all of the cases that we've been watching tonight. He has shown a bit of heart for each defendant. He is a great guy. He really is. But making them accountable and setting that payment plan encourages them to go get a job in their field or any job, because they're going to go to jail if they don't. And if you get them back to working, it's a start on the path to success.
Does want the victim restitution to be paid first. You need to make your best efforts to get this case paid off, Ms. O'Brien.
I will, sir.
You need to make this right.
I will.
Further, you're going to have the obligation of contacting Greenwood County Court Services immediately after this hearing.
Okay.
I'll give you a number to call. Actually, I don't have that number currently before me. Mr. Lett, do you?
316-322-4153, and they will assign her the CSO.
Okay.
That's actually the Butler County Court Services office, Ms. O'Brien. They can get you to where you need to go. So
Okay.
just call that number and get set up with your probation program till it can be transferred administratively to Lyon County or whatever your county of residence ends up being.
Okay.
You need to stay out of trouble.
I will.
All standard conditions, Ms. O'Brien.
I will, sir.
Okay. Mr. Lett, is there anything further we need to address regarding Tiffany O'Brien at this time?
I don't think so, Your Honor.
Mr. Paw, are you aware of anything further?
No, Your Honor. Thank you.
All right. Ms. O'Brien, do you have any questions about the court sentencing orders?
No, sir, I do not.
Call that court services office number as soon as you get off the meeting, Ms. O'Brien. Good luck.
Okay.
I hope you're successful on this
Thank you.
probation program.
I will be.
All right.
We're rooting for you. You can do it.
Thank you.
Nothing further. The O'Brien matter is in recess, and this meeting may be ended for all. This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Charles Allen Tucker. It's case number 2024 CR 158. Charles Tucker appears at the Greenwood County Courthouse's Zoom location. Mary Ann Shirley is defense counsel. Jill Gillette is Greenwood County attorney. This matter comes before the court at this time for arraignment. Docket notes indicate that Mr. Tucker appeared before the magistrate court on November the 8th. He waived preliminary hearing at that time, was bound over for arraignment today. Ms. Shirley, does your client desire the charging document to be read to him?
No, Your Honor. He has been fully advised of the charges, potential penalties. He is fully aware of that and has, in fact, the plea agreement completed. He's had the opportunity to review everything that's contained in the plea agreement that he has in his possession.
All right. So what is the announcement here at arraignment?
He is entering his plea to an amended first offense of attempted failure to report, a severity level 8 person felony. The other 2 counts are to be dismissed.
All right. So is there an amended charging document here?
Judge, we usually file those with the journal entry of the plea.
Well, okay. I thought Ms. Shirley said that there's 2 counts that would be dismissed.
There's 2 counts in the complaint, Judge. It's count 2 that will be dismissed. Count 1 is what he's pleading to, an amended count.
All right. So what we're altering here is not only the taking off the aggravated failure to register, This would be a normal failure to register as an offender, and then would drop 2 severity levels due to it being amended to attempt. Is that correct?
Yes, Your Honor.
It's an interesting factual question how someone can attempt and not complete the crime of failure to register as an offender.
He did not obtain a driver's license because of some stupid little quirk with the Department of Revenue. He is fully compliant now. He had gone in and completed every single thing on every vehicle, phone number, everything, but this one Department of Revenue form was incorrect, and it is corrected now.
Right. Not exactly satisfying the court's question, Ms. Shirley. Thank you for your attempt to do so. Very well. Mr. Tucker, you've been present when the attorneys have made their announcement as to how your case would be handled.
Yes, Your
Do you
Honor.
understand what's going on here?
Yes, sir.
All right. I want to address with you right from the outset that the crime of attempted failure to register may not actually exist, that you would be accepting conviction, if the court accepts your plea later, to this perhaps even non-existent offense in order to receive the benefits of a plea agreement. Is that correct?
Yes, Your Honor.
You understand that if someone someday in jail or prison or on the outside tells you that that's not really a crime, you can't go back and undo it once you've entered a plea to this.
Yes, Your Honor.
Because you're doing this to receive the benefits of a favorable plea agreement. Are you not?
Yes.
Okay. And you still want to do this?
Yes.
All right. I've got a number of questions I'm going to have to ask you regarding the taking of a felony plea. There's something asked of you that you do not fully understand. I will give you the opportunity to confer privately with your lawyer. If you need that time for private advice, just let the court know. All right?
Yes.
All right. State
The
your full
speaker's
legal
messed
name.
up. I'm sorry. It's kind of hard to hear.
Why is it hard to hear?
The speaker's messed up in here. It's kind of staticky.
Judge, when the TV is hooked up in the commission room, it screws up the microphone. When they turn the TV off, it helps the microphone, but it screws up the sound.
All right, Mr. Tucker, it's important that we understand each other. Are you going to be able to hear me well enough to understand a whole series of questions I have to ask you?
Yes, I believe so, Your Honor.
I don't like being staticky.
I understand.
Because I'm usually very loud and very clear.
Right. I'm just getting up close to it so I can understand better.
All right. Again, I'm going to have you start off by stating your full legal name for the record.
Charles Tucker.
How old are you right now?
46, Your Honor.
What's the highest level of education that you've attained?
I've got my GED.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
Yes.
You are going to have trouble understanding?
No, I'm hearing you just fine now. Now that I'm closer to it.
I'm not talking about whether you can hear me or not. I'm talking about, do you think you're going to have any difficulty understanding any of the legal matters that we're going to be discussing?
No, Your Honor.
We've got a lot of things to go over. All right, Mr. Tucker, have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No.
Are you supposed to be taking prescription meds that you are not currently taking?
No.
So you believe as you sit today, your mind is clear and you have a full understanding of what's going on in court?
Yes, Your Honor.
Did you receive a copy of the original charging document in the case?
Yes, Your Honor.
All right. We went over this earlier, but I'm going to ask the question a different way. Do you understand the nature of the charge of attempted failure to register as an offender?
Yes, Your Honor.
You understand it better than I do then, Mr. Tucker. As long as you think you have an understanding of what you're pleading to, that's what I'm really asking here. You think you do?
Yes, Your Honor.
Okay. I did not make a note, Ms. Shirley, as to what type of plea your client is entering. What is your understanding? You might want to unmute yourself if you address the court.
I apologize, Your Honor. It's my understanding he's entering a no contest plea, Your Honor.
Of course. All right. You understand, Mr. Tucker?
Sorry, Your Honor, what's that?
Okay, you looked a little distracted for a moment. What was that all about?
Are you okay?
It's just my end, I think.
I think they're trying to address the sound issue.
Mr. Tucker?
Yes, Your Honor.
Okay, I've got a lot more questions I need to ask you, okay?
Yes, sir.
You understand that if you enter a no contest plea, you're not necessarily admitting that you did this act which is charged by the state, but you're also not contesting that you be convicted just the same. Do you understand that?
Yes, sir.
You also understand that when you enter a plea of no contest, you're giving up any legal defenses that you might have had to the charge?
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any of their witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you can present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that in such a trial, you would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that, Mr. Tucker?
Yes, sir.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described?
Yes, Your Honor.
You also, do you understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, Your Honor.
You understand that you have a right to appeal a guilty verdict if you have a trial?
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes, Your Honor.
Are you aware of the sentence that could be imposed as a result of this no contest plea that you are attempting to make?
Yes, Your Honor.
Let's go over those. You would be on the non-drug offense grid under the Kansas Sentencing Guidelines Act. In the most favorable criminal history category of I, you could receive as little as a 7-month prison sentence. In the worst criminal history category of A, you could receive up to a 23-month prison sentence. So the sentencing range is 7 to 23 months in prison, depending on your criminal history. As you sit today, we do not know with certainty what your criminal history is. You better than anyone else here, Mr. Tucker, should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of their research as of date of sentencing, that will determine where you fall along the level 8 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
You also understand that if your criminal history at time of sentencing would put you in either the A or B box, in other words, you have 2-person felonies on your record that would count in this case, you would be presumptive prison. Do you understand that?
Yes, sir.
I didn't hear your response.
Yes, sir.
All right. You also understand that you could receive up to a $100,000 fine for this offense.
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing. You understand that, sir?
Yes, sir.
You also understand that if there are any special rules that apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence.
Yes, Your Honor.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Have you had an ample opportunity to discuss legal matters like that with your attorney before proceeding here today?
No, I think I'm good, sir.
Okay, you don't want any more time with Ms. Shirley before we go further?
No.
So you're satisfied with the services and advice she's given you, is that correct?
Yes, Your Honor.
All right. Now, this no contest plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
Okay. You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So let me ask you formally, how do you plead to this charge of attempted failure to register as an offender?
Guilty, Your Honor.
Okay, your attorney
Right.
said you were entering a no contest plea.
Yes.
So is your plea no contest?
No contest, Your Honor.
Factual basis, Ms. Gillette, this should be interesting.
He just can't get over it. I love it. I love it. Judge Ricky just can't wrap his head around how they're going to pull this one off.
Your Honor, the defendant received a DUI. The DUI was in a chemical test failure, occurred on, the occurrence date is June 16th of 2022. Subsequently, his license ended up being suspended due to compliance with the DUI things. His driver's license expired during the time that he was restricted, interlock, and suspended. He has to keep a driver's license on record. He did not realize that his license was not current on his registration paperwork, and he had not renewed it when it expired. They no longer send out the expired cards on everyone, especially if you're under restriction or suspension. So he did not renew his driver's license, and there was not a current driver's license or Kansas ID on record for his offender registration. He has since gotten it corrected and gotten it taken care of, but the time period that he did not have a ID or current driver's license on file was from April 25th of 23 to October 23rd of 23. And then it went from October 24th of 23 to April 20th of 2024. But there was no driver's license or Kansas ID on file for those time periods. And once it was brought to his attention, he did get it corrected.
So you would acknowledge that the amendment to attempt is just basically to give the defendant a better overall disposition of his case. Is that correct?
Yes, Your Honor.
All right, Mr. Tucker.
Yes, sir.
Do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for attempted failure to register as an offender a level 8 non-person felony.
Yes, Your Honor.
Excuse me, that would be a person felony. Is it still your intention to enter that no contest plea to the level 8 person felony?
Yes, Your Honor.
All right. Shirley, other than the one that the court has somewhat at length discussed, do you know of any legal reason why the court should not accept your client's plea?
No, Your Honor.
Ms. Gillette, are you aware of any such legal reason?
No, Your Honor.
Mr. Tucker, are you aware of a legal reason or any good reason why the court shouldn't accept your plea of no contest here today?
No, Your Honor.
Court will accept the no contest plea made by Defendant Tucker and finds that that plea is made voluntarily. He has an understanding of the nature of his charge in the state that it is, and the consequences of his plea, and a factual basis for the offense does exist, at least as far as the completed act is concerned. The court finds the defendant guilty pursuant to acceptance of his no contest plea, and adjudges him therefore convicted of attempted failure to register as an offender, a level 8 person felony. Count 2 is dismissed pursuant to plea agreement. The court does direct that an amended charging document be filed to set forth properly count 1 as amended. Court orders a pre-sentence report be completed to accurately determine this defendant's criminal history, and the court will set an appropriate date for sentencing.
Are we going to the January 23rd, Your Honor?
We are. Mandy, would you suggest a time?
9 a.m.
What do I have at 10?
Let me look real fast.
We gave out at the 9 a.m. on a plea or a waiver of prelim, Mandy.
Let's move it to the afternoon, Mandy.
Oh, I'm sorry. I was looking at the 26th of December. Okay.
So January 23.
Yes, at 11 a.m. then.
Okay, let's move it to the afternoon.
Okay. 1:15 p.m.
I will suggest 1:15 p.m. on Thursday, January 23. Counsel?
I have a 1:30 docket. Can we make it later, either earlier or later?
Okay, when will you be done with your docket?
Hopefully no later than 3 o'clock.
Okay. Well, because you're saying hopefully, I'm going to move this to 4.
Okay.
4 o'clock p.m. on Thursday, January 23 is the sentencing date and time for the Tucker case. Mr. Tucker, you must be in the same place where you are today. Hopefully there'll be less audio issues than you're experiencing today, but you will need to appear at the Greenwood County Courthouse in Eureka, Kansas for your sentencing and no other location. And I appreciate you fighting through any hearing problems that you've had today to appropriately answer the court's questions. Thursday, January 23, 4 o'clock p.m. for sentencing in the Tucker matter. Mr. Tucker, can you write down a telephone number?
Yes, I have a phone number.
For what?
Oh, he misunderstood.
I'm asking you if you can write one down. I'm going to give you one.
Oh, okay. Go ahead, Your Honor.
I'm glad you have a phone, Mr. Tucker. I truly am. The number is the Butler County or the head court services office, and you need to make contact with them right away and follow their directions regarding any pre-sentence assessments or anything else they need from you between now and time of sentencing. So you need to contact them today, okay?
Yes, Your Honor.
That number is area code 316-322-4153.
4152?
No. 316-322-4153.
5-3.
Yes. It's Butler County Court Services, okay? Make contact with them this afternoon.
Yes, Your Honor.
All right, Mr. Tucker. You have any questions, Mr. Tucker, about what we've done here today?
No, Your Honor.
Okay, and you got that sentencing date and time written down?
Yes, Your Honor. January 23rd, which is a Thursday at 4 p.m.
Yes, and where do you need to be?
The Greenwood County Courthouse, Your Honor.
All right. You've understood everything well then, Mr. Tucker. I will again expect you to make that call to court services just as soon as we get done here, okay?
Yes, sir.
Follow
I'm
their
gonna
directions.
do that
Ms. Shirley,
right away.
anything further?
I have nothing. Thank you.
Ms. Gillette?
Nothing further, Your Honor.
Very well. Then the Tucker matter is currently in recess. This meeting may be ended for all.
That was his last case of the day. And his give a crap button was so broken. It is so great to see Judge Ricky making jokes like that. He's really funny, but it's in a very, I don't know, authoritative kind of way. It's weird, but I love it. I love his sense of humor. Oh my gosh. That was so much fun. And yes, we will be doing another Judge Ricky-thon probably December 6th, I want to say. There were several cases that got put on the December 5th docket. So I'll either be editing them for the 5th or the 6th, one of the two. But yeah, I love when we can do that. Every case he had was just a banger today. It was so much fun. There was something interesting or funny, or it tied into one we've seen already or something. It just, every one of them was just chef's kiss. And chat was really fun tonight too. Of course, as always. Bandit. Hi, baby girl. Hi. How's my most beautiful baby? Hello, angel. Oh, I love you so much. Oh, I feel so blessed right now. Yes. Bandit. Oh, she's so gorgeous. Oh my gosh. Right, baby girl. And she cuddles up to me at night. Earl does too, but Earl does not like to be pet. I mean, okay, he wants to be pet, but it's on his terms. Billy's my cuddle bug when he takes my desk over, but Bandit will just lay there and let me pet her and just cuddle. It's so great. I love her. I love her so much. Of course, Ava is always there. She lays on me. Oh, she's thirsty. She gonna go get a drink from her Aussie kitty fountain. Thank you all for spending this time with me. I had a blast, and I will be back. We are going to have such a great time together because I'm not doing it as a members only, but I'll be doing body cams and taser videos and entitled Karens, you name it. I have been collecting. I created a playlist, and I've been just kind of stuffing good videos into it. So You're welcome, of course. Thank you for coming. You were entertaining as always. And you know exactly what I'm talking about. Absolutely. Thank you so much. Be safe, be well, sleep sweet, and much love.